25G306327. Hey, John. I'm not even videoing. I'm not even on here. My mistake. Did you, sir? Did you take that?
Yeah, he was working out.
Yeah. Yeah. All right. Good morning, Mr. Hyder. Your appearance.
Good morning, Judge Steve Harper, and on behalf with Mr. Schroer, who sits immediately to my left, Judge.
Mr. Eschenroder, your name?
Tanner Eschenroder.
All right. So your client was referred for a screening and assessment after he pled guilty to operating while impaired. The incident occurred April 13 of 25. He pled guilty to on June 9th to operating while impaired, and the super drunk, the 6th month, was dismissed.
Actually, Judge, Judge was visibly impaired.
What did I say?
Impaired.
Well,
You said, yeah, he, never mind, Judge, you're right. I'm sorry. Go ahead.
That's okay. It's early. It's all right.
Sorry.
So he pled to operating while impaired. The super drunk was dismissed. We do have the verification of his AA once a week. There's been so I ordered it May 22nd. He's gone 5 times, once a week. I do have to tell you, I'm concerned about this, but at any rate, have you had a chance to review the report with your client? And are there any material additions, corrections, or deletions?
There is not, Judge. Thank you.
Anything you would like to say on his behalf?
I would, Judge. I want to let you know that Mr. Tanner completely cooperated with the police in this investigation. This incident had no accidents, absolutely had no property damage, Judge. He works 6 p.m. to 3:30 a.m. Monday through Saturday at Ford Motor Company in Monroe. He's had absolutely no incidents with the criminal justice system whatsoever. He's a really good young man, Judge. This has been, I believe, a one-off. I don't think we're going to see him back. I noticed in the recommendation they're requesting 12 months probation, bi-weekly testing. Judge, I noticed in your bond, on the bond recommendation and in your bond order, you did not have him testing bi-weekly. So I'm kind of thinking with his work hours, that might be a little hard for him to hit. So, Judge, I'd ask you to reconsider that recommendation of bi-weekly testing and not have him testing, because he hasn't tested for you on bond. There's been no indication that he's relapsing or drinking. He's going to his AA as court ordered. And then, Judge, I'm also asking about the 12-month probation, that you reconsider his 12 months probation and make this non-probation, Judge.
Mr. Eschenroder, anything you'd like to say?
No, sir. He covered most of it.
Okay, so you and I need to have a conversation here. You're 22 years old, and you had almost 3 times the legal limit. Now, I don't keep stats up here. I don't write things down. But I'm telling you, the likelihood of you revisiting the criminal justice system and I'm talking about somebody that has a 2-2 on the blood 1 year after they're legally able to drink, is exponentially high. Statistics tell me that if I have 10 of you that come in here at 22 with a 2-2 on their breathalyzers, 70-80% are coming back. Might be tomorrow, might be in a year, might be in 2 years, might be in 4 years, might be on something else that involves alcohol or drugs or both. I mean, you were drinking. You also admitted that you consumed marijuana. On top of that, I see you have a medical marijuana card. I don't write laws, and I'm not going to make my own laws. I happen to think medical marijuana is bad for you. I don't even know why you need medical marijuana. I'm not going to make a big issue of this. You use it daily. You have any physical problems?
I have scoliosis in my back.
What do you do at Ford Motor Company?
I package. I started on the line and then I transferred plants to now I'm packaging.
I'm just telling you, this is not good. You can think what you want. I know what I'm
Understand the
talking.
statistic. I understand what you're telling me.
Good. Well,
I
then
didn't
we,
mean to interrupt you though.
I'm sorry?
I didn't mean to interrupt you, my bad.
Oh, you're
But I
fine.
understand what you're telling me with those statistics, but that I won't be back.
Okay. And I'm not quarreling with you. I hope you don't come back. I just want you to understand that I've been doing this a long time. I've never had somebody, well, not one person say to me, Judge, I'm coming back in front of you. Not one. So just be careful. 14 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. I will not violate you if you test positive for THC, so long as you possess a valid medical marijuana card, not because I think that's the right thing to do, but because that's the law. So I'm not gonna quarrel with the legislature or the voters or anybody else. So if you have a valid medical marijuana card and you test positive, I will not violate you. You're to submit the chemical testing, PBTs and ETGs as follows. Bi-weekly for 4 months. If you're clean, I'll make it monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to attend the Victims Impact Panel. You're to attend AANA. I'm upping it to twice a week until you're in an intensive outpatient treatment program. I think you need it. I'm just telling you, when I see these breathalyzers or blood draws this high for somebody that young, a big red flag goes off. So AANA twice a week until an intensive outpatient treatment with aftercare. So once you get into intensive outpatient treatment, you no longer have to attend AA or NA. Also attend the Victims Impact Panel. Also serve 4 days jail credit, 1 serve 3. I'll let you serve those on our court work program. So 3 days court work program, there's a $35 a day charge for that for a total of $105. 300 fines, $225 costs, $75 victim's rights fee, $50 justice assessment. So fines and costs are $650. You do have probation fees of $280 for a total of $930. Cost of recovery is $225 for $1155, and then you have your court work program fees. Totals $1260. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. If you violate probation, you could get 93 days. You may be eligible for early probation, or early termination, I should say, early discharge from probation. So in another 7 months, 7 months from today, if you're clean, you've had no violations within the preceding 90 days, you make application and you will be discharged from probation. That's by law. Do you fully understand the sentence, sir? I can't hear you.
Yes, sir.
You have any questions at all?
No, sir.
Okay, and you understand the alternative is 93 days, correct?
Yes, sir.
Judge, did you include the screening fee?
I did write it down. Maybe I didn't include it.
I just got a different amount.
5, let me double check. 5 1/4, $650, 8, 930, 1130, 1155, 1260. You are correct. Thank you again. I wrote it down and I didn't add it in, so it's 1320. All right. Can you pay all of this, Mr. Hyder?
Can you pay it?
Whenever I can pay it.
He can pay it. Can you have 7 days, Judge?
Well, is he working today?
Yes.
Yes, he is. He goes in at 6 today, Judge.
I would like him to come up here today and get his initial reporting. So if you need 7 days, I'll give you 7 days. If you don't, just pay it when you get here. It's up to you.
Can I get to 7 days, please?
Yeah, I'll give you until the 1st of July, okay? In fact, why don't, yeah, and then come on up here and they'll give you your initial, They'll explain the order and go over everything with you, okay?
We did, okay.
All right, good luck to you. Thank you. Thanks, Mr. Hyder.
Did you say you wanted him up there today, Judge?
Yeah, he should come up here and be instructed by probation. Okay?
Good deal, man.
Okay, he'll be up there today. Thank you, Your Honor.
Thank you. Have a good day. Good luck, sir.
On these dockets sometimes, but I wouldn't say that. I wouldn't say it the way it's said, but he's obviously frustrated, that man. Okay, let's see what we can do about taking care of some business here today. Langston, you've got a few things. You had a good day yesterday. You had a good day yesterday.
Oh, Mr. Collins, no, the first case, when Mr. Epler gets here.
Reagan, you're leaving now?
Uh-oh.
I'm sorry?
You're leaving now?
I need to speak with my.
Oh, okay, I thought
No.
you had had enough and you were taking off for a cruise or something.
She'll be.
Yes, sir.
Judge, on this-
This is Brian Collins?
Yeah, no, excuse
All right,
me.
hold on, let me
Sure.
do all this to make sure. The important thing, Mr. Collins, he's a very good man, you're here, but the important thing is you make a wise choice and you move on with your life. In a good direction, and hey, everybody makes a mistake. Everybody makes mistakes, it's just how you fix them. You can do it, you can, I think you're a very capable man. Being able to fix this, get on the right track. And we won't have to see you move on with your life, you know. This is stuff that's, I think, is fixable.
Yes,
Who's the prosecution of that?
Mr. Epler on this case.
Who's got comfort in Mike?
Judge, what I wanted to do on, I think we can move this basically, but what I did want to do when Mr. Epler arrived.
Yes, sir. Oh,
Right. At least on the first case, the unlawful possession of a firearm by felon, the gentleman to my right, stand up, you know, it was his gun.
boss everybody, right?
Right. He was gonna talk to him, to kind of tell him that, hey, he was the one who actually left the gun. And as far as the other case, I mean, it is what it is. So I was hoping that I can move that one today.
Okay, when he gets here, you'll talk.
When he gets here,
Okay, he's on his way. Yeah,
right?
all right.
So I just want to ask Mr. Collins to have a seat, and then Mr. Eckhart be here. So Mr. Eckhart could actually talk to the man himself. And that way, whatever he concludes. And then we'll just try to move everything today. So let's just wait for Mr. Eckhart to see it. Well, wait till he's better with you for the best.
I'm looking at the gun case now, there's no. Talk to Mr. Adams and.
Okay, in the sequence, it looks like Mr. Collins gets arrested, on May 23rd. And then is indicted in October of 2024 for this unlawful possession. But so he arrested in May, and then August 13th. Is he arrested again?
No, sir.
Says on Tuesday, perform an annual address verification required at report. I learned that he no longer lives there. Still reported an address. As of this date, he has not reported an address change. So, but what had happened, you must have posted a bond on
Yes,
this first arrest. Hold on May 23rd, right? And then thereafter, he gets an indictment on 10/16. So both of these cases were indicted on the same day by the grand jury. When did you post a bond on this second case? Do you remember? I've got it.
Let's say no.
11/27. Okay. What is your current address right now? Do you know?
9 Circle Q.
In St. Augustine?
Oh, no, sir. In Orange.
Okay. I've got a St. Augustine address on this first indictment. I've got Groves, Gulfway Drive on the second indictment. And you've got, what is your final address? The final one you want to use?
9 Circle Q is the address.
Sir?
When they went to the wrong place over there.
What's your address?
9 Circle Q, Orange, Texas. Seven 7630.
It's 77 what?
630.
630.
Yes, sir.
No. It's because right like it's, they like it's going there, but when she got stuff at the planning, so I'm sorry, I forgot to say what that. You got stuff. I said, I'm sorry, I forgot I had it in there. You don't say, oh my gosh, I'm surprised it's funny. I did not know anyone said that. Just tell you what he said at the scene. Well, once the sun gets here, he talking, there's something, you know, I.
Okay, corrected this. So we're gonna wait for Sonny to get here?
Yes, sir.
Is that it? Okay, stand by then. Well, have a seat. And Langston, you've got Leon Goodman, the third.
He's hired a lawyer and he's here.
Thank you.
Where's,
I checked this morning, there is no letter, correct?
They told me this morning, the mom was here, said she hired somebody.
probation?
That's his mama, and that's him. So outside, the first thing she said is she got somebody. Who's the lawyer you hired?
I talked to attorneys, I talked to ombudsman, and I talked.
Who did you hire?
Who did you hire?
Jaws Cole. Jaws Cole.
Cole.
Giles.
Giles. I think he's out.
Giles. When did you hire him?
9580 something,
I can't use my, like, when did you hire him?
Friday. Saturday.
When, did you give him like, the notice of your
He said he was
appearance?
sending it through,
Sir?
he said he was sending it through yesterday morning.
Well, if he, we don't have anything from
He
him.
hasn't, you found anything into the case yet, as far
Yeah,
as I can tell.
you have his phone number, don't you? Call him up. Tell him he needs to be here to help you. I mean, if he's representing you, he needs to be here. We don't do it by telepathy. You got to be here in person. And something needs to be in the file. He knows it needs to be in the record, and there's nothing showing that he's representing you. Until such time that happens, Langston Adams continues to represent you. You can say you hired somebody, but you've got to show with writing and records that that's been done so that it's official. Otherwise, the way the rules are, he continues to be the attorney. But call him up and we'll wait. You know, we got other things to do, but call him up and tell him we're waiting on him. Okay, Javon Jobert.
I got complete paperwork. That's gonna be the legal this morning.
Sincerely, clerk?
Please, unless you want to take it, she ain't signed yet. But that's
It
okay.
didn't happen quite yet.
That's you?
Yes. that's
Okay,
gonna be-
he's gonna take fix something up for you, go over it.
Okay.
We'll end up disposing that. I've got two cases though.
That's gonna be the book. They can dismiss one and
One-
leave the one.
Okay, which one do you?
The one that's gonna be dismissed is the.
9-8.
Oh, I'm sorry.
Dismissed, Your Honor.
Okay, thank you.
Yes, sir. And then I got,
Patrick Plaisant,
he's here. When you.
where's he?
He's right, come on.
Mr. Pleasant.
When we were in here last, we gave him time to hire his own lawyer. And I think the guy that he has now, will have is Rife Kimberly. Can you tell me Rife is the person we talked to? Yes. So Rife is gonna be his lawyer.
I think they should, not as.
Yeah, we don't have anything that shows that. So we'll just reset it a week if that's what y'all want to do. If you're gonna hire somebody, it's,
I can.
you got some time to do that.
He's some talking about being knife.
I just want to put paperwork saying he's still on.
Yes, nothing. Until that's done officially, he continues to be your lawyer. So you can get advice from him, but where's the,
Revocation. Not the whole one.
I put on a month vacation and
I can also do it. Right, it's up to you.
This one is a lot. He found his sleeves in the state of Massachusetts.
right.
Stop this.
But my point is if we did it 1 week, that'll be in English.
Well, I got you.
hey, what's Sarah?
Yes, yeah.
What did, who's the analysis on this?
It was a 0.133, I believe, Your Honor. Yes.
What's up? Y'all work something out?
I got an offer on that basis, 205, 505, but with him having, saying that Rife is gonna be his lawyer, I didn't.
Yeah. Yes.
I didn't
You're-
step on anybody. No,
You're on the
I'm a public defender for him.
public defender form. Okay. All right. That's one way to do it. Lawyers are all, in this court, are all pretty good, but okay, we'll wait on you to hire somebody then. That's what you want to do. We're gonna give you like 2 weeks, okay? Reset it 2 weeks.
Thank you.
It's one way to do it. We had it done it. Yeah, get a resetting from that lady. Okay,
Thank you,
you're gonna
Joe.
work on.
Yeah, I need to sign her up.
Thank you.
I signed him up now.
I have Adria Richard, and that's been reset. That case has been reset. And then is Darius Smith here? Mr. Smith? Is David Grove working on something?
He was here.
Jennifer Gamble? maybe Reagan was talking to her. Christopher Glanville. Mr. Glanville, maybe she has a. Jose Roque,
She was.
is that you? So Reagan Minaldi is your attorney, correct? See? Abogado, usted? Okay, she's outside. She'll be back. Gary Metz. This is Gary Metz here. Where's Mr. Metz? That you? What is this? Okay, let's take that up.
Good morning, sir.
Hello. Okay, this is clause number 16-24069, and you were Gary Dwayne Matt?
Yes, sir.
And Mr. Metz has been on probation since 2016. 10 years deferred for unadjudicated probation. And let's see, let me look at this one. Is this hearing based upon this January 14th
Yes, sir.
administrative hearing? Let's see.
And it's basically based on payments.
Is it all about money?
Yes, sir.
Oh. You say your family is priority. It ought to be, and you will pay when and what you can. If it's up, but if you're not paying what you can, your family is going to suffer.
Yes,
Because you
Yes,
will. All right. So we've got fees of 6,280, right? And as of 24 December, last December, you were in arrears in the amount of 5,440. Was there, how much of this is restitution?
He doesn't have a restitution.
None?
It's
Oh,
all
okay.
supervision fees.
All right. Okay, so that's the most important thing to me is always restitution. So what's the total amount that the defendant has paid over 9 years?
Over 9 years, his total credit is $3,880, sir.
Okay.
And he has gotten back on track. He's making regular payments. He made a big payment in April to try to do himself back towards where he needs to be.
Where are we?
Right now, he's $4,490 in arrears, but he's been making payments.
Okay. Is he still on an active?
Yes, sir.
Do we need that?
For him to be on active,
Uh-huh.
not necessarily, sir.
No.
Active.
Well, and that was lowers some of his fee, right? If you
Yes.
put him on inactive.
Mhm. And he wanted
It's not a problem. If he hadn't been a problem, then he needs to get rewarded. If it's just playing out the fees, let's stop the fees that from accruing and then get that on an inactive basis. And then when that gets satisfied, then he can quietly go back to his own life.
Yes, sir, because he should be done next year.
Good. All right. Where are you working, sir?
Equipment share off of Highway 90 in Beaumont,
Okay. And how much you making an hour there?
26.50.
Okay. All right. Well, that's about 60 annually, so. And what's his total amount? So we have a,
His total amount is $4,490. That's how much he
Okay.
gets.
do you have like a budget that you can, see, it's going to be frozen. So it's just a matter of whittling that down
Yes, sir.
regularly
I'll get it whittled down.
and, you know, 400 gets that in 10 months
Yes, sir.
and 200 is in 20 months.
Yes, sir.
All right. What else on this thing?
That's awesome. That was the only thing.
Okay, we'll just review it in about 3 months, see how we're doing. Okay, all right. Otherwise, Yeah, good. All this is fixed?
Yes, sir.
Good. Make the best out of your life.
Yes, sir.
And your family.
Yes, sir.
Yes, sir.
Okay, thank you, sir.
Cedric,
Yeah.
sorry.
Think, we've got two lawyers, working on this. We've got Langston Adams. Three.
My plea, I'm set.
Great. Right.
I just said.
Okay, come on up. David Grove and Reagan Minaldi are, handling the three handling matters. This is going to be Ron Gilbert.
I'm sending in the plea to you now.
Thank you. Education case.
I'm 18 years. There was supposedly arrested for very never been. This time.
Thank you, Judge. I'm sorry about that. I'm trying to resolve.
Okay, that's okay.
I think we got it done.
You jump on Javon Joker. That's you, ma'am?
Yes, sir.
Okay, which one are we going to dismiss?
9-8, Your Honor.
Okay, so we take up first 24 CR 1399. And you were Javon Wilshon Jobert, present with your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? And can we proceed in a summary fashion?
Yes, sir.
What do you need, a pen?
I need a pen. I got one. Thank you.
Here. That'll be $10.
Yeah, I got you. No problem. Just go ahead. Listen.
In summary, this indictment alleges that on or about June 3rd, 2024, in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer by striking the peace officer about the face with your hand as he was in the course of arresting you. You understand what you're charged with here?
Yes, sir.
This is classified as a second degree felony. And what that means is if convicted, this says y'all checked third degree. What is it? The second degree on the caption.
He's second degree.
Yes, Your Honor, that's correct.
Is that wrong? I'll fix it. A second degree felony, in this case, that means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
The agreement's been reached in your case where you are pleading guilty, placed on deferred or unadjudicated probation, fined $500. That can be up to 10 years in length. And as part of this agreement, 24 CR 1398, attempting to take a weapon from an officer, that is dismissed. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this second degree felony of assault on a peace officer? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked with State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Did you understand it? Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it is admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 was made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, sir.
Stand by just, sir. What was going on here? What was going on?
Oh, I went out with my friends and coworkers and things like that, and I ended up getting a little too drunk.
I'm sorry, say that again.
I went out with my coworkers
Uh-huh.
to like a house party, and I ended up getting a little too drunk, and I
A little
didn't
too
drive
drunk.
home. I didn't drive home. I had pulled my car up closer to like besides of like somebody's parking lot, and I just slept in my car. And then, but they what I was told was somebody seen me in my car and they thought I was dead or something, so they called the police. Then when the police came, it was
Okay. Are you aware of what really happened?
oh, as far as the altercation with the police is?
No, this whole thing. What time did the police come up to see you and to help you? Do you know?
Evening time, probably like most 6.
5 a.m.
Oh, okay.
You're parked in a vacant lot on West Grove Circle in Groves. Your engine is running and you're out. You're lucky you didn't die of carbon monoxide. They saved your life, probably. So let's see. So they were helping you out of the car and you began punching the officer with a closed fist. And let's see, you were taken to the ground, continued wrestling and kicking the officers. This was just alcohol? Nothing
Yes,
else?
sir. Yes, sir.
Mhm.
No medication.
Is that normal? Is this normal behavior for you?
No, sir. Intoxication.
Well, the car was running when they found you. You're lucky you didn't die. And this is 4:57 in the morning. Okay, so you were arrested. How long did you stay in jail?
The day too.
Gonna be more than that. You don't punch officers on my watch. You don't strike the officers like this. Who's saving your life? That's incredible. All right, anything else?
Nothing.
All right, I'm going to find then, and you are pleading guilty in this case, is that correct?
Yes, sir.
Are you pleading guilty voluntarily,
Yes, sir.
knowingly, intelligently, and because you are guilty?
Sir.
All right. State's Exhibit 1 has been admitted into evidence without objection. And I'm going to follow this agreement and find that you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. If you do well, it will be shortened to 1/3, 3 1/3. There's a fine that you must pay in the amount of $500. And how long did you say you were in jail?
Like a day or two.
For 4 days. You don't even remember, do you?
Well, I didn't.
You were in there, it says 4
days.
days. So you got credit for 4
Yes,
days.
sir.
All right, you're going to, do a weekend in jail, another weekend. I want you to report into the Jefferson County Jail on or before 6:00 p.m. They will release you Sunday. No one punches, fights and punches out law enforcement without having to go to jail. You don't do that. They're going to be protected as best they can, dealing with people, especially someone like you who were saving, really your life was saved in a car that was, you were unconscious in running. And it's just incredible that you would, that intoxicated, that you would go and, I guess it was a great thing that a car full of nuns didn't come up and help you. You'd have punched them out, huh? Anyway, you will report on before 6:00 p.m. at the Jefferson County Jail for Friday, and they'll release you on Sunday, 1 weekend, to add to the other 4 days. You take care of yourself better than this. That's no way a lady should be acting, responsible behavior for a lady or anyone else or a gentleman. All right, seated probation officer, thank you. Langston,
I'll take.
1398 is dismissed. The other case is dismissed on the lady.
Oh, perfect. Thank you, Judge.
Christopher Glanville. Who is your attorney?
Mr. Howell.
Where is this? Hey, oh, hold on. She needs your thumbprint?
Yes.
Okay, yeah. Okay, Mr. Glanville,
Yes. I'm sorry.
that's you?
Yes, Your Honor, I'm sorry.
Oh, straight.
Yeah, don't roll it like. Oh, that's okay, we're gonna do it too.
You're Mr. Glanville now?
No.
Oh, wow, you're punch on. Mr. Glanville, yes. Christian. 24 CR 2384 is now called the state of Texas versus Christopher Allen Glanville. That's you.
Yes, sir.
Present with Ms. Nowdy, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about November 10th, 2024 in Jefferson County, Texas, you committed the state jail felony of injury to a child. Do you understand 14 years of age or younger? Do you understand what you're charged with, sir?
Yes, sir. Your Honor.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes, sir. Your Honor.
An agreement's been reached where you would be
God, you sure to them?
uh,
Thank you.
pleading guilty, placed on deferred or unadjudicated probation, which can be up to 5 years, fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. Do you understand? Is that is the plan?
Yes, sir. Your Honor.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir. Your Honor.
How do you plead to this, sir? Guilty or not guilty?
Guilty, Your Honor.
Are you pleading guilty voluntarily?
Yes.
That is on your own free will and because you are guilty.
Yes, sir. Your Honor.
Are you with Marcus States Exhibit? Yeah. Did you sign that document voluntarily?
Yes, sir. Your
Understand
Honor.
it, discuss it with your attorney, or the contents all true and correct?
Sir.
States Exhibit 1 is tendered
No
in,
objection.
so without objection, it's submitted. This states, among other things, that you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
I'm going to follow this agreement, sir, and find you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt in support of your guilty plea. But I'm going to defer any finding of not find you guilty so long as you follow these terms and conditions of probation, as we're going to place you on deferred or unadjudicated probation as opposed to adjudicated, which means that's where you were found guilty, sentenced, and then placed on a form of probation. We call regular probation. This gives people a second chance. Just make the most of it. You'll be fined $500. This will be for 5 years length. There will be terms and conditions of probation, which are normal and customary for this type of offense. And there's something special that we have a program for a moral recognition therapy or family or something from family services that helps people who, I guess, lose composure and do something they regret.
And Judge, he has informed me that he is already enrolled in the BIP class and
The
he
what?
is the BIP, BIPP.
Yeah, BIPP. Mhm. We have
He is-
that as part of our program.
I believe he's 2 weeks out from getting his certificate
Oh,
and
good.
completing that class.
You did that on your own? How long? You started that already?
Yes, sir.
How long
Few
have
weeks
you-
left.
How long have you been?
16 weeks,
Okay.
15.
You did that on your own?
Through CPS when they got involved with my case.
Okay.
There was a family law component to,
The victim on this is 11 years old, Judge.
Yeah. And
So CPS would be involved. The other case, Judge, was refused by our office because she refused to cooperate as far as the choking accusations were concerned.
Oh.
I encompassed all that with the offer that I made, and I'm hoping this is just a one-time incident for
Is
this
it?
gentleman.
Yes, sir.
What would cost it? Drinking?
No,
Because you said, it looks like you had a beer. You were drinking a
I
beer when they showed up.
began to drink a beer when the officers arrived. Yes, sir.
But, why would you do something like this in your right mind? It doesn't make sense. Was it anger?
I believe so. Yes, sir.
Okay. All right. Do you have a grip on it?
Yes, sir. I do.
What is it that's been done to seal the deal so that this won't happen again?
I learned a lot in these book classes. We've also been doing meditation and long walks and just self-healing,
No.
knowing my wrongdoings and not being able to repeat myself.
Okay. How many children do you have?
I have two.
Okay. And the victim here is one of your children.
Yes, sir.
Okay.
Yes.
All right. What's the greatest gift you can give to your child?
Not be the person that I was that day.
You know, you're on the track. The greatest gift you can give a child is to set an example,
Yes, sir.
because children will naturally emulate their parent.
Yes, sir.
And if you were assaulted, don't expect them not to be,
Yes, sir.
because they're learning a lesson. You're the role model. I think you understand that.
Yes, sir. I do.
So, Clark said, you know, from here on, set the best example you can.
Yes, sir.
All right. Yeah, this could have ended up a lot more serious for you.
Yes, sir.
If you didn't have courage or what. She takes care of her business. You gotta take care of you.
Yes, sir.
All right. You will continue and complete that BIP or anger management program. Here, thank you. As a condition. Probate, other conditions that the probation office will go over with you. Make sure you follow them. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 2 years in the state jail.
Yes, sir.
You've never been arrested before, have you?
Very, yes. Traffic tickets in the past.
Yeah. Other than a traffic ticket, nothing
No,
else.
sir.
Well, you're the role model,
Yes, sir.
and your wife. You gotta set a good example. You got people who were gonna emulate you. You're just not living your life. You got your children who are a vital part. You are a vital part of their direction that they're gonna head in and the choices they make. Set a good example. Please see the probation officer. Thank you. Mr. Goodman, you know where you ended up in this, don't you?
Sir.
You tested positive for drugs. And you're gonna be arrested. You don't come to court high on drugs. You shouldn't be on drugs in the first place. That's one of your bond conditions. Don't commit a crime. That's the very first bond condition. Come on up. You tested positive for THC, tetrahydrocannabinol marijuana. What's his bond, please? Your bond is revoked. It is now $20,000, and you must have a drug patch as a condition of bond from here on. Do you understand? This is no way to handle a third-degree felony. You're charged with a third-degree felony of injury to a child, you're looking at up to 10 years in prison. So you're going to deal with this in the most irresponsible way possible by using drugs? Foolish. You're not learning anything from this. You're not learning anything. You're not on the right path at all. Okay, so who do we have representing you? Is it Ms. Ryan?
Yes, but he said he hired Charles, but yeah, I'm here just for,
Anyway, you're taken into custody and next time I catch you with drugs, you won't have a bond. You'll just sit it out in jail until this thing's over with. You understand? All right. Okay.
something real quick.
We'll take care of everything. Sit down. Do you need to get something from him? Okay, the bailiffs are going to take care of that and get it over to you, whatever his personal matters are. Okay? Thank you. Yeah, I have a Gianna Jimenez on the queue. Motion
Is that for dismissal?
to revoke probation. It's a dismissal.
Of the MTRP.
Great. Okay. Then on this date, that is being signed.
I got Collins ready for you.
Brian?
We sent it.
Brian Collins? Yeah, go ahead.
Oh, we fell.
Yes, I can afford it. Yeah, I don't want to change it. It's nice after all this time.
I can't access it.
Okay. Oh, it's Brian Collins. I recognize. Look, Mr. Adams, what are we doing?
10/10 and to.
I don't have any papers.
We sent.
Brian Collins, we have 2136 is a plea in that case, and 2135 is to be dismissed in consideration.
Great. Okay, we now call 24 CR
Fingerprints?
2136, the state of Texas versus Brian J. Collins, present with Mr. Adams, his attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about August 13th, 2024 in Jefferson County, Texas, you committed the third-degree felony of failing to comply with sex offender registration requirements. Do you understand what you are charged with here, sir?
Sir.
This is a third-degree felony, and this means that if convicted, you face no less than 2 nor more than 10 years confinement in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range for such an offense?
Yes, sir.
An agreement has been reached where you would be pleading guilty, sentenced to 10 years in prison. That will be suspended. You will be placed on regular probation for 10 years. And I don't see a fine. And 24 CR 2135, another case pending, will be dismissed as part of this agreement. There will be terms and conditions of probation, which are normally customary for this type of offense, which at the end of the day, it's essentially continue to comply with the requirements of the registration. That's the basic thing here. Okay, is that your understanding of the plan?
Right.
If I follow this agreement, you have no right of appeal.
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? It is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit. Did you sign that voluntarily?
Yes, sir.
Did you understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
And without objection, admitted. Among other things here, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily.
Yes, sir.
You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 made a part of the record for all purposes.
No,
Sentence report is way.
Absolutely.
Okay, I'm going to follow this agreement, sir,
Yes, sir.
and find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here, admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of failing to comply with sex offender registration requirements. I'm going to place you on probation. You are hereby found guilty beyond a reasonable doubt, sentenced to 10 years in prison. That confinement is suspended. You were placed on regular probation for 10 years. You do well, we'll shorten it in a third. There will be terms and conditions of probation, which we are normally and customarily require defendants, as you in this type of case, to follow. And they're really not hard. Just do it and continue to faithfully register as you must. If you fail, your probation could be revoked. You could be sentenced up to 10 years in prison, which we don't want. So
No, sir.
fix this. It's fixable. Here.
Did it wrong?
Yeah, good one. Thank you. You're registered properly right now, right?
Yes, sir.
Okay.
That's state register. They just went to the wrong address.
Yeah, but I got with I've marked through this thing a couple of times here already, so you got to slow down wherever you're moving around.
Yes.
Where they are. Please see the probation officer.
Thank you. Appreciate you.
And she needs his thumbprint real quickly.
Mhm.
And here the 2135 is hereby dismissed on Mr. Collins.
And then 2-1 down here. Straight up and down. That's all.
Oh.
I guess other ones.
Jennifer Gamble. Miss Gamble. No.
Three cases.
5657. Are you Jennifer May Gamble? Okay. You are here with your attorney, Ms. Manalo, and you have three cases here. 24 CR 2355, a third-degree felony of credit card or debit card abuse. And oh boy. Okay, these three are not in sequence. Okay. So there's a third degree felony here in paragraph 1 of this indictment, but it's alleged you have 3 prior felony convictions. And that means that this third degree felony, if you're found guilty, it jumps up from 2 to 10 years, a third degree felony, to second degree felony, 2 to 2 years in prison, if this is all true. And on 2356, it's another, they're all credit or debit card abuse. This one's a third degree felony as well with this in 2356, this with the same 3 prior convictions. So you're looking at second degree felony punishment in that case, up to 20 years in prison. And finally, a third one in 24 CR 2357. This was filed as a state jail felony, but because of the 3 prior convictions, it's which are not in sequence, but this state jail is bumped up. It's a state jail felony on paper, but it is punished as though it were a third degree felony in this case, up to 10 years in prison. So you can do the math. Yeah, it's a total of 50 years and up to 50 years in prison.
And Your Honor, on that one, it's actually still just a state jail felony, just to be clear for the record. I don't know what they put them in there, but they're not in sequence. So it really only if she had 2 other state jail felonies would it bump it up to the third degree felony. Those were all non-state jail felonies.
I'll stand that here. I mean, I'm gonna look.
Local is how I've been saying it.
She would actually be, Your Honor, you pointed that out, and with the other two cases, she would end up being habitual on those, because the last page of the indictment like that, where we didn't see it.
On the 2 third-degree felonies that she is alleged of. If there are sequenced, then she would be, her status would change.
No, but the primary offense is a state jail felony.
Well,
No.
the others are third degree felonies.
The other
Your
2
Honor.
third-degree felonies, Judge.
Like they were confusing with that because there was a large space on the second page, but we didn't notice the third page. There's large spaces if there were no other prior, but on the third page, it does have them in sequence, as you pointed out, and it's so she would be habitual on the third degree felonies.
She would be 2nd degree on the state jail.
Yes, sir.
This would.
Hey, there's just one third-degree felony.
There's 2.
Two of them.
There's 2 on there?
Yeah.
Okay.
Felons
Okay.
in state jail.
And 1 state jail.
Yes.
Okay. Does she know that? That she's looking at 25 to life?
I will make sure that she knows that. I don't know that we realized that until just
Okay.
now, but I will make sure that we are.
It sounds like that's gonna be resolved though. I get the feeling with that's just. That's a. 2 shots at. They have 2 shots at her on the habitual one, and then 20 years on the other one. So 2 lives and 20. That's sobering. Okay, Jose, roll call. And this is, come on, 25 CR 22. What are we doing here today?
Judge, I'm requesting a 3-week reset on him as well. He needs a translator and I have not been able to get with him about an appointment to go through his discovery and talk about his offer or anything like that. And then next time, whenever we are in court, I'll guarantee that.
You have somebody you're gonna be able to use?
Yes.
Okay, get a resetting 3?
Yes,
Good,
Judge.
thank you.
Thank you, Judge.
Yes, ma'am. Is that it?
That's it for me.
This is the gentleman who testified.
I done.
Did you hear it?
Yeah, probably did.
Yeah.
Is license still around? Is, okay, we're still on Bryan Collins, right?
No, we're done.
Here. Oh, that was that extra one.
Yes.
And then Leon Goodman, the third we took care of,
Reading on here.
and Javon Joseph, now Darius Smith.
Yes, sir.
Morning, on.
Hello. And we now call cause number 24 CR 1703, the state of Texas versus Darius Charles Smith. You were here with Mr. Grove, your attorney and the state's attorney. You were indicted earlier in this case by the grand jury on the 3rd-degree felony of unlawful possession of a firearm by previously being a convicted felon. And that carried with it, it's a 3rd-degree felony, so you were looking at no less than 2 nor more than 10 years confinement in prison. And you were ineligible for regular probation. So we got really 2 options. The agreement that was made by the parties is that whatever sentence shall not exceed a cap of 4 years in prison. So you were looking at imprisonment no less than 2 nor more than 4 years confinement. You can also be placed on deferred or unadjudicated probation. But again, regular probation, the third option is not. Is that also? Is that an option here in this case? Regular probation?
You, Your
I
Honor,
say
are
it
not,
twice.
you're not limited from doing that. You can do that as well if
Okay.
you choose to.
Yeah, he didn't use the firearm.
No, sir, he
He didn't actively use it. He was in possession of it.
Correct.
So
that's correct, Your Honor.
so it was not used or in a way that would then prevent him from being placed on regular probation.
Yes, sir.
Everybody.
Yes, sir.
Go ahead. Mr. Grove, you may go first. And then Mr. Smith, you have a chance to be heard as well in the statement. Okay.
Right, Judge, Mr. Smith is not here to tell the court that he has not ever been in trouble or he has had any problems. He has had some problems in the past. He also has been,
How much time?
he has been on deferred adjudication, I believe, on one occasion successfully completed it. He has one case which was revoked. He also, when he has graduated from high school and is currently attending Lamar Institute of Technology. He is
Doing what? What's the plan?
Technology. Sir,
And what plan?
P-Tech, well, process technology, get my associates in science.
And what do you intend to do with it?
Like give a job in one of these plants, like OCI, LNG, things of that nature.
Good.
And while he's attending school, he also has a full-time job. So he is spending his time well. He has 5 children, and he spends a lot of time with the 5 children every other weekend, basically. And although he's had some problems in the past, and I'm not trying to downplay that as much as possible, but he was stopped by the police with a firearm in the car. It was in his car. The weapon was found under the seat. It was an unloaded weapon, did not have the magazine attached, although the magazine was in the car. I'm not trying to downplay that. He told the authorities when he first was arrested that the reason he had the weapon was because he had gotten it from the children of his girlfriend to take it away from them. It was still in the car. He shouldn't have had it in there. There's no doubt about that. But he did. It was not as he was actively using the weapon or intended to use the weapon. Again, he has a number of arrests and a number of probations which he's been successful. But we'd ask the court to consider giving him one last chance and to allow him to receive either deferred education probation or regular probation on this case, and not force him to go to the Texas Department of Criminal Justice. And again, I point out that he did graduate with high school, go back to school and get his diploma. He also is continuing his education so he can support his family. And he's very sorry about this. I would ask the court to consider giving him probation.
Okay, stay.
I disagree with that. Judge, the thing I want to highlight, there's so much in this report, but the thing that really just rings so true is when on page 4, when he admits during his PSI that he's been daily smoking marijuana. That means that while he was out on your bond for this particular case, he was violating it every day. He was violating the law every day. It has a direct connection with the fact that the underlying felony that he's convicted of is possession of marijuana. It was a state jail felony amount. Yes, he did get probation for that. It was a straight probation that requires a conviction. But here's the thing about probation. The hope is that we're going to get somebody to rehabilitate.
Better.
Well, he didn't rehabilitate. He got out and he just kept smoking dope. Now, let's look at what the facts are of this. He was asked by the officers whether or not he had a gun. His response was, "Not that I know of." Then in the search of the car, not only do they find the gun, they find a magazine that goes with it that's loaded. They find an additional magazine to a separate deal. So it's not like he accidentally had some weapon here. And when he's given an opportunity to talk to PSI, he blames it on his quote unquote homegirl giving him that gun. And that judge, I was generous when I took what he got before and just doubled it from a 2-year sentence that was probated for 2 years to 4 years. His counsel kept coming back trying to get probation for him. That's not something I agreed to. I agreed to cap because I think 4 years is fair. I stand with making that offer suggested sentence today.
You want to say anything, sir? This is your time if you wish.
I have no excuses for what I've done.
I'm sorry?
I have no excuses for what I've done, but I know I'm trying to correct my life and just do better and stay away from all the activity that you see on my report. I'm trying to be here for my kids. I'm trying to be right.
Yeah.
Yeah. So I'm the biggest role model. I'm trying to show them the right way to live.
Yeah, but what's going on here?
Bad decisions. I'm doing the wrong thing. Like that's not me. I'm not a violent guy. Like I don't plan on continuing doing these acts. And I feel like I will be probation served.
How many misdemeanor convictions do you have?
5.
It's your life.
Looking.
11.
11. So
You said 5? You don't even know?
Wow.
This is your life. You should know more intimately than anyone. I'm telling you something about you that you don't know about your own life. Then you got the illegal, that marijuana, Ellis County mess that you were placed on probation, regular probation for. And then that gets you the conviction. But yeah, you don't only have 9mm bullets in your car. You've got 7 AR-15 magazine loaded with 7 live .223 caliber bullets also on the rear floorboard.
yeah.
And a separate 9mm bullet in the rear, on the rear floorboard behind the driver's seat. Plus, they located a chunk of marijuana from the center armrest. You were convicted of something in 2017, illegal possession. How many times? 1, 2, 3, 4, 5, 6, 7, 8, 9. I'm speaking 9 separate possession of drug charges. They were misdemeanors, but 9. It really, it's just as though you can't get out of the hole there. And then, I'm sorry, we forgot the felony, Ellis County that you were on probation for. That was a felony. And so you're mixing drugs and bullets. Great. And we know you're not going to throw a bullet at somebody. The bullets are in there because there's a gun that they were going to go into. They were a firearm, and they're 2 separate types of bullets.
Yes, sir.
And this is the vehicle that you drive the kids around into?
No, sir, I don't have that vehicle.
You used to?
Yeah, I used to. But I didn't have the firearms in there or the bullets. That was just that day.
Who drives around with bullets in the car only, huh? Who does that? No, what are you doing it for?
So
You can't even explain it because we all know why. It fits in a gun, a firearm.
yes, sir.
And you're not supposed to have that. But this is foolish when you've got a family at home.
Yes, sir. Correct, no.
5 children, really?
Yes, sir.
5 children.
Live at home. Support them as well.
You're mumbling. I
I
cannot hear
still
you.
support them as well. You know what I mean? I help out and I pay child support.
What's the role modeling going on with the marijuana and the bullets? What are you teaching the children, sir?
You're right. I'm teaching.
You think you're not role modeling properly?
I'm gonna do it around them, but yes.
You don't do it around them. It's what you are.
Yes, sir. You're right. I made it a habit when I was 15.
It's what you are.
Yes, sir.
You are supposed to be setting an example for the children.
Yes, sir.
You're the role model. They're going to do what you do. You think kids don't figure out, the kids don't ever get in this car?
Wow, they all play sports now. I'm looking at athletes.
You were a child once.
Yes, sir.
You know you pick up on things. You're not a dummy.
Yes, sir.
Children learn, they're always learning, and they're most impressionable from their parents. But you also completed a drug offender education program, 7 years ago, but you know we're serious about all of this.
Just might just beat you in the back.
You're not handling it seriously.
Silent.
I know you appear to be taking responsibility
Yes, sir.
and accountability for it, but this has consequences.
Right.
I mean, this is serious. You're looking at up to 10 years in prison for this charge. But you know better. You've been warned.
Yes, sir.
Anything else? Go ahead.
Yes, sir. Very briefly, Judge.
Yes, sir.
Apparently the probation officer who prepared the pre-sentence report views Mr. Smith somewhat differently from what Mr. Ham does. She says that he appears to take full responsibility and accountability for the offense. He is attending community college and is gainfully employed, as well as taking care of his children. She recommends that he stay on probation and receive some trainings. What she suggests is a moral recognition therapy, or that, and then also that he receive a substance abuse assessment, which obviously he needs that. There's no doubt about that. And I would ask the court to consider giving him one last chance because of the fact that he has done well on these other things, although obviously he has not done well on the possession of the drugs and the weapons.
Those are kind of important.
Well, yes, sir. And I'm not trying to say that those are important, Judge. I'm not trying to say he's an angel or anything like that, but he has done well in these other areas, I believe. And I believe they would, it's one of those things where at least he has done well on that. And I think he could still be saved and society would be better if he were able to do that. But of course, it's up to you.
All right. Anything else from anybody? If not, I'm going to find that, sir, you have pleaded guilty in this case voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 that was entered into the record on your entry of your plea back on May 28th of 2025 to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. This is the agreement is whatever sentence shall not exceed a cap of 4 years in prison. Listen very carefully. You are hereby found guilty beyond a reasonable doubt. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. Do you understand what has happened today, sir? Do you understand? Right. Do you grasping that? That your family and everything else that you put secondary to other things. I'm going to hold you responsible.
Appreciate you, Your Honor. So,
Sir?
like I said, I appreciate you, Your Honor. So, I really wish I could go through probation and complete my terms and go through classes. Like you said, you have an accent, so.
Well, the way it sits right this moment is you're not going to get that. You're going to prison. You understand? How many children are at home?
Wow.
Do you understand this is inevitable?
So this is serious, yes, I know. So I know.
It's your choices that affect the family.
So, and that'll be filled.
And Mr. Ham is actually right on the button on everything he says.
Sure.
You deserve 4 years in prison. This is what I'm going to do. I'm going to suspend that and place you on probation for 10 years. You're gonna 10 years because you need it. There's something wrong here in your backsliding process. There will be terms and conditions of probation that you must follow. And you're on really the thin ice. You know what I'm saying? Failure is not an option for you. It'll be real fast. It won't take much of a violation, but you got no drugs, no guns, no bullets. You will complete this moral reclamation therapy class, and I am going to ask the probation office to look into any other programs that might be important here to help him complete this. This shows you did 2 days in the county jail. You're going to do more than that. And you'll do it you're working during the weekday.
Yes, sir.
You're going to do your weekends are going to be busy. You're going to check in
Yes, sir.
to the jail on or before 6:00 p.m. and will be released at 6:00 on Sunday. And you'll get credit for 2 days each weekend. And you're going to do 90 days,
Yes, sir.
90 days, 3 months in the county jail. Hopefully this is like putting your hand on a stove. You're going to remember and do better. But note this is another conviction. Next time you're looking I believe has a habitual felon. The next time you're charged, which is a minimum 25. Try to rear a family doing life in prison while you're doing life in prison. If a family is important to you, you should come third. There's a great saying, our creator is first, others are second, I'm third. You ought to be, but you keep putting yourself first. And that's why you're here. And that's why you're suffering. Most importantly, your family's suffering, others are, because of your bad mistakes and your poor role model. Fix that immediately, sir. Will you?
Yes, sir.
Do more than just nod and say, I will. You made a promise, you're making a promise to every court when you're in doing a case. I'm never going to get in trouble again. That's what I hear. But folks show up. You're just gonna, if you fail, you're not going to just be letting yourself down. Others who rely on you, who ought to be more important to you than your acting. Okay, anything else? No. You'll go over with the probation office, then you report every Friday. Until you get to, that'll be 15 weeks, 15 weekends. You get credit for 2 days. Could have been a lot worse.
No,
See her and then her.
I've already got his number.
Anything else? Yes. Yes.
You've got a dismissal that I sent you just a while ago too.
Oh.
Okay.
That's not what.
Yes.
Please pardon me, Your Honor.
Okay, your pardon.
Thank you. Your Honor, I'm here, Leon Goodman. Young man I met over a month ago.
The one I just put in jail.
He tested positive this morning.
Yeah, yeah. He's in all kinds of messes. You want to look at his file and learn more about this man? He's not what you think. He's got to get fixed. He's heading down the wrong track.
That's
what we're trying to do.
That's what Ogden wants to do.
Help him.
I will.
He's on the fast track.
Judge.
But I mean, that's what
I'll take the case. I'm taking it.
Okay, good.
He said he hired.
Huh?
He said.
It says he's hired Giles Cole on the 20th. We make sure, but you and Giles can work together or work this thing out. But he says he's retained Giles, who wasn't even here.
What were the bond conditions you said, Judge?
Just the drug test.
Well,
Yeah, his bond was doubled like it would be in every case, and then he has to have a drug patch that I would do in every case. That's what I did. So
Based on what Mr. Samuels told me, I have no objection to leaving the bond at its original amount, but with the other conditions, Judge.
Your Honor,
Because I know its family is strayed for money as far as.
he's trying to get his GED. He's back in school, but he's smoking weed, and I told him. So, but he listens to me.
I know, but it's ironic that he's working on his education, but acting ignorant.
At one point, I did too,
I
Judge.
mean, this work, where's the education going?
I understand.
It's supposed to make him smarter and to make better choices, and but
Judge,
here's what I do is I treat him like I do everybody. Their bonds get doubled. And it's an example that we set, and then the drug patch.
Ogden's going to be like a mentor for him.
Judge.
That carries a lot of weight with me, that he's willing to make that sacrifice. And that is why I'm asking you to deviate from your bond.
But here's the deal. We got to remember, they're all special people. They're special people. We open the door for one. We open the door for everybody. This is fair. This is like the scales of justice. What's fair for one is fair for all. And I'm going to treat him like I'm going to treat others. If we're going to treat him differently, everybody else gets treated in similar situations, and that's the way it's going to work. So give me some good reasons why the bond should not be double like normal and customary. Sometimes it's even greater than double, depends on what they test positive for.
Yes.
He tested positive. THC.
THC.
Smoking. I met him about a month ago. He came and did some work with me. I got to know him a little bit better. His mom couldn't pay me. They couldn't.
I understand.
I'm taking the case free of charge.
How well,
I believe,
how well do you know?
I believe in him.
And how well do you know?
How well do we know anybody?
I don't know. I said something about him that reminds me of me.
You're taking a leap of faith.
I'm taking a leap of faith. And I will be accountable for, could he come out? I won't hear.
If we're gonna release it, you're gonna have to have a drug patch too as a condition. But
Give me a drug patch.
I think he's already.
here, bring him out, please, Tommy, thank you.
Is he?
He's gotta get his drug, gotta have a drug patch before
That's
we can do that.
It's no, Ellie.
Sorry for this stuff.
Oh,
Send it to the.
too bad, too bad.
Shape up. Come on, do with this.
Yeah.
We're gonna deal with this.
Yeah. Gotcha.
But don't lose strength. If these are important decisions.
Yes.
And he needs to
Yes.
handle it responsibly and as a grown up, because he's being dealt with like a grown up. And he's got to take responsibilities and make good choices. Hey, Leon,
Yes, sir.
how's it going in there? I wouldn't want to be in there. How many people are in there?
About 30.
30.
Yes.
And they're,
Pocket next door.
you buddy, they're just, you don't want to live with those guys, right?
No, sir.
How long do you want to stay in jail?
Not at all.
I wouldn't, a minute. Anything you learned here in the last 30, 40 minutes?
I don't want to be here. I don't want to be here.
That's your destiny when you use drugs illegally and commit crimes. Do you understand?
Yes, sir.
I mean, do you understand that?
Yes, sir.
It's kind of like a shock probation in there. We pulled you through. We wanted to see how you would sense and understand and appreciate the environment that you have elected and chosen to make by not following the rules. That's your destiny unless you change, not tomorrow, not next week, not next year, but right this moment.
Yes, sir. Yes, sir.
Is that, do you understand and appreciate that?
Yes, sir.
You need to have a drug patch. The bond is going to continue to be the same. You have to have a drug patch before you leave here. Get that, you'll be released
Yes, sir.
on that bond. And then he's got a next event.
You want to give him 24 hours, Judge, maybe?
You can't get it here. The drug patch, like he has to go to the place and
Yeah.
put it on.
They send a confirmation to the
Yeah,
court
that's-
once he gets it.
They even.
So within 24 hours, if you don't have the confirmation in your file.
It's just a suggestion, Judge.
You get it.
If they don't have a program that gets you, you got the end of the day.
Yes,
By the end of the day, that's what you can do.
yes.
You understand? And confirm it with the person who puts it on. You'll be then, as a condition of bond, the bondsman will be notified that you have a drug patch so that that can be monitored.
Yes, sir.
But you fail that, and then you fail. You'll be right back there, and that'll be where you sit until we can resolve this, which could take a while. You understand?
Yes, sir.
But we're serious about it. But the thing is, we seem to be more serious about it than you do, and you're supposed to be taking it far more seriously than us. Are you? Are you understanding and appreciating rule following is vital? You don't follow the rules, you get punished. These kind of actions can affect you the rest of your life. If you're convicted of a crime, a felony, it's with you the rest of your life. And doors of opportunity are closed. You don't have the options that you would otherwise have to live out your dream of what you want to do, as long as it's the right thing. You know, you want a good dream, not a bad dream. And absolutely no drugs, no firearms. Following the rules like all of us in this room do. We have to follow the same rules. And you can imagine how accountable I would be, or Mr. Samuel would be, or the prosecutors or bailiffs would be if they got caught doing something. We'd really be a big target. But we don't do that because we come to appreciate and cherish the more important things, freedom and being able to live in a free society and enjoy your freedoms, but follow the rules.
Yes.
All right. That's my lecture as a parent to you.
Yes.
But this is like a spanking. You learn from it. You don't want to do this again because you don't want to get punished. Do you understand and appreciate how close you are to a destiny of failure and a conviction follows you the rest of your life, and you can't it's like carrying a gorilla around. It wears you down. And then you get tired of, nope, we're not going to hire you. We're not going to hire you. We're not going to hire you. You get tired of that because that's all you hear. You don't want to lose opportunities. So you got to live your life making the right choices.
Yes, sir.
And we're going to help you with the drug patch. But it tests positive. Shame on you.
Yes, sir.
Okay. He has the next event, an announcement. Did we give him a resetting? Okay. David, you're still on this, right? I see Ogwen's helping you here.
Giles is his attorney.
Oh, that's
But
right.
he hasn't officially hired, so.
Yeah,
okay.
Mr. Cole.
Until he gets in the game.
Substitution and I'll add you.
Add me. I'm taking
Because we haven't done with that letter yet, so technically I don't have him as an.
Okay.
And I can just replace you from my.
Okay.
Okay.
Well, get your hair done. You know, so you can see. You don't want to be driving dangerously. Where are you in school? It's a GED you're working on,
Yes,
right? Okay, where are you?
I'm at the Texas Workforce.
Yes, sir. Okay, where are you?
I passed one of my tests. I need 2 more to pass so I can go to Lamar, take my official. I take my official. They put me in a slow pace class so I could function.
Yes, sir.
So now they took me out and I'm going back to the fast paced class.
Okay, I want you to give me, I want to see how you're doing on your tests.
Yes, sir.
I'm gonna be watching you, okay? All right, we got people watching after you.
Yes,
You
sir.
do your part.
Yes,
You gotta do the heavy lifting. We're gonna support you, but don't let us down, yourself down,
yes,
your family down.
yes,
Do you understand how many people there are here involved in this, in your decisions? You don't live alone. This isn't just you. You're not on this planet by yourself. You touch a lot of people's lives and they touch you.
yes, sir.
So don't disappoint others. Don't disappoint yourself.
Yes, sir.
Yeah, you're capable of doing better. That's what's frustrating to all of us. We know you're capable. Do it. We can't drag you across the finish line. You got to run across. Do it. You're capable of winning the race. Okay. All right. Get a resetting and we'll see you back. And hopefully there'll be a lot of good news I hear next. Okay.
Yes, sir.
All right, sir. Thank you. Anything else? We're in recess. Thank you.
We're unarresting him.
Yes. He is placed back on bond.
I'm gonna figure it out.
He's got 24 hours to get this drug test.
Good morning. Are you Matthew Wadsworth? And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor. Yes.
Are there any additions or corrections?
No, Your Honor. Not from this one.
All right, Mr. Rojas, you may proceed.
Yeah, Judge, this is a cap of 8, the agreement, I think it's a cap of 8, and just based on the criminal history alone in the PSI, it looks like.
It looks like you did a very good job of getting that agreement.
That's kind of what, not that I did a good job, but I think that may be doing a favor to Mr. Wadsworth. However, there are some things I'd like to point out. If you look at, I'm not talking about his felony criminal history. The first page of his, or I guess, rolling into this second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2000, all one, in January 2002, they all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them. Got some more in October 2002. Then after that, he goes and basically he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present case,
From after the 2002 and to the 2019, there were seven additional felonies.
Yes.
7 additional felonies.
Yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me most of the time when he's committing offenses is when he's off his medications. He's been back on the meds now in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with safety to get help with his drug issues. And he understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that. And even as he was pointed out by the probation officer in the report, he's indicated to them that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better. And he tells me he's ready to make that change. And he does have some statements to make to you at the appropriate time.
All right, go ahead, sir.
I only wrote this because I get really nervous.
Sure.
So I said, this letter is to ask you for some help. I'm a drug addict. I can, oh no. Basically, listen, man. I was a bad kid until I was ADD poster child. I was put on Ritalin. Then I did really good. The Ritalin, I went from straight F's, farting in class, thinking it was funny, picking my nose and eating it, all that stuff. I thought it was, I just was bad. They put me on Ritalin. I went from straight F's to straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something. And I hope it don't hurt me, but I got beat up. I had a robbery in 1992. When I got out from that robbery until 2000, when you started, 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on in my head. Our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2018. I'm sorry, 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it, my truck, my tools, and everything. And I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. And we started fighting, I was losing, and I hit him. If you do give me the chance, what I need is some help staying on my meds, because I start feeling like I'm doing better sometimes, and then I stop taking them. When I stop taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. Wadsworth, here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying.
Okay.
The problem is you're 51 now, 52?
51.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said, this is.
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors, 21 felony convictions, 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And out of the, and in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements, and things like that. So that's 38 felonies. The last, and I get a lot of this was from '02, and a lot of it was in the same big scenario.
19 of them was in one.
But it didn't stop then. You were put back on probation in 2017. So not that long ago, given a probation, it was revoked. So you were given an opportunity. Mr. Smith.
I completely stayed out of trouble since then, though. Not one single incident.
Well, you had 2017 an unauthorized use of a vehicle felony, 2018 an obstruction of justice in Pike County.
Yes, ma'am.
2019 an escape. That's the one that's
That was my
pending.
last one.
Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is, in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account of probation, where he said the part about the baseball bat is not true. A dresser fell on top of it.
I saw that.
He's still not accepting
I
responsibility.
hit him with the cane.
Hold on, don't
I'm
speak
sorry.
over. I let you talk, so
I'm
don't talk
sorry.
over anyone else,
I'm so
please.
sorry.
I believe probation is absolutely right, that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8-year sentence.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement, because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not. You'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff. Try again, same number. All right, let's see, Mr. Nichols. We're going to try again on Christopher Norris.
Can I help you?
Hi, this is Judge West. I'm calling.
Hello.
How are you, ma'am?
Good.
Good. You have Mr. Norris with you?
We have got him coming on his way right now.
Okay.
To retrieve him from class.
Okay. Just let me know as soon as he gets there.
Wonderful. Thank you, ma'am. I hope that's good. He is coming through the door right now.
Thank you.
Hold on one moment.
Hello?
Hi, Mr. Norris. This is Judge West.
Oh, okay. Is it you, Judge West?
It's me. How are you?
Okay. I'm doing good.
Good.
I'm fine. I'm just ready to go home.
Well, we're gonna go through what we've got today and figure out what we're gonna do. This is cause number 01. I think they put me on hold. Hello?
There we go. Whew. Technical issues.
Ma'am?
Technical issues for a moment.
That's okay. We had some nice music to listen to for a minute. All right, so this is cause number 01-84078, and it's the state of Texas versus Christopher Stephen Norris. For the record, Mr. Rojas is here in the courtroom. Hold on a second. Can y'all please keep it down, sir? Mr. Rojas is here in the courtroom representing Mr. Norris, and Mr. Nichols is here representing the district attorney's office. Mr. Norris is charged with the offense of murder and was found not guilty by reason of insanity many years ago, and was ordered under 46C to inpatient treatment. And I have received the yearly report from the Russ State Hospital where Mr. Norris is currently staying, and that report is dated May 12th of 2025. I'm going to take judicial notice of the court's file, including that report. The first part is the forensic evaluation of violence risk assessment. This was prepared, let's see, hold on just a second, let me get to the end, by Dr. Mary Ann Robinson, February 28th of 2025. The finding in that report with regard to future violence is that Mr. Norris needs to be still in some type of restrictive setting due to the current issues that have been exhibited over the last year. Talks about a potential less restrictive setting. However, he is in that less restrictive setting at the Russ State Hospital, which houses the less violent patients. Also, in addition to that, I have the forensic psychiatry report to the court, This has information prepared by Dr. Calvin Gurka, and the recommendation is that Mr. Norris be recommitted to the Russ State Hospital for further treatment towards the objective that he be able to transition to the community at some later date. In addition, I have received the physician certificate of medical examination for mental illness, the first prepared by Dr. Gerke as well. The finding in that report is that Mr. Norris is mentally ill, that he is likely to cause serious harm to others and suffering severe and abnormal mental, emotional, or physical distress. There's some details in there regarding recent behavior and things like that. It makes the finding that current inpatient treatment is still warranted. Also, okay, so that's it. All right, and it's got some history also as well. Is there any other evidence with regard to this matter, Mr. Rojas?
No, Your Honor.
Mr. Nichols?
No, Your Honor, we just asked the court to take judicial notice of the entire file dating back to his original commitment in 1998.
Yes, I think I did, but if I didn't, I will do that. All right, so Mr. Norris, at this time, I am going to find, based on all of the reports, that Mr. Norris is mentally ill, that he is likely to cause serious harm to others, that he is suffering severe. Hang on, sir. That he's suffering severe and abnormal mental, emotional, or physical distress. I am going to find, based on all of those reports, that inpatient treatment is appropriate and order Mr. Norris to be remain at the Russ State Hospital for a period of 1 year, and then we will see where things get. So, Mr. Norris.
Yes, I feel like we can do without my lawyer. He's not helping me none.
Well,
I feel that all these statements that the doctor's saying is not true. I mean, it's like he's picking something up on me every week. He's like, so he's got things on me. It's not one thing, it's another thing. You know, it's kind of hard to get out. I mean, I was in another ward, and I mean, it's hard because there's a lot of fighting going on here. I mean, it's hard to make it a whole year, you know, and, you know, I try my best, but years is a long time to be around all these mental patients because they'll just run up and hit you, and they call that a fight. And they say you're aggressive. But I haven't been in no aggression fight, period.
Well, there's other issues that concern me, Mr. Norris. We tried a couple of years ago, or it's probably been longer than that, where we tried a less restrictive facility, and I actually agreed to do that. That did not work, and I ended up having to have you put back in the Russ State Hospital. So I am not comfortable with any release to a less restrictive environment based on what all of these reports say. My advice to you, Mr. Norris, is to participate in everything that is offered. Take your medication as ordered, and then we'll see where we get in a year. All right? Y'all, thank you. Y'all have a good day.
Thank you, Your Honor.
Thank you. Mr. Burbank, you've got Devrin Byerly. Good morning. Morning, Ms. Mulkey. Good morning, sir. Are you Devrin Keith Byerly? And Mr. Byerly has two cases that he is currently on probation for, and motions to revoke probations have been filed in each of those. Cause number 18-28800, on probation for violation of a protective order, and also in 18-29063 on probation for violation of a protective order. Those are both deferred probations. Mr. Burbank has filed requests in both of those cases asking that I set bonds. Sometimes I do that without a hearing, but due to the nature of the underlying offenses as well as the new alleged offense, I wanted to come and hear from probation and the state as to what your position is with regard to any bond that I would set. Ms. Malfino?
Yes, ma'am. Judge, obviously I will defer to whatever Ms. Johnson thinks is appropriate. I do want to let the court know I did reach out to the complainant in the underlying offense. I've actually maintained contact with her just on a friendly basis since the original offense that I handled back in 2019, just to be able to assure the court that those issues do not involve that complainant, the issues that he's having now. There is no issue with the Hartley family, which I was glad to hear. Obviously, my concern is that there's been another assaultive offense. There's also been an allegation of a possession of a controlled substance. So 2 new offenses while on this bond, in addition to multiple violations, in addition to everything that Ms. Johnson has already made available to Mr. Byerly. So I know that he's entitled to a bond as he is on deferred.
Maybe he is without certain findings. So that's why we're here. So just also for the record, Mr. Byerly, and I know you know this, but I'm going to go through just so that we're all clear what the allegations are in that motion, and just that they're allegations, and obviously they haven't been proven true. But it looks like you have an allegation that you committed an offense of assault April 21st of 2025, that you tested positive in a urine sample for opiates, that you did not provide verification of attending the JCDI program. Looks like there was another urine sample that tested positive for alcohol in April of this year. Then it also alleges that you committed a new offense of possession of a controlled substance, May of this year, that you possessed crack cocaine, which is the same date as that offense, and that you were at a other location other than your residence at approximately 3:19 a.m. on May 29th, the date of that offense of this year. So what do you have the status? I know the lab, we've had some issues with lab results. Is there any idea on that, Ms. Malfino?
I do not know, Judge. I would venture to guess that with it only being several weeks ago, we probably do not have anything. I'm happy to reach out to the agency and ask if they can expedite that through the lab and be prepared for a hearing whenever the board.
And Ms. Johnson, thank you for being here. And so what is your thought, I guess, with regard to setting a bond? And if I did set a bond, what specific conditions do you think would be helpful?
I received his case. I became his officer in February of last year.
Okay.
And since then, I have put him in ISF cognitive. I have put him in JCDI. Prior, he's at an MRT. He tells us that he understands that he has a drug problem, but then still continues to go do what he's doing. We've tried to help him as much as we can. And I went and visited him, I believe last week or 2 weeks ago, and he told me the reason he would get on a bond was so he could go work out of the county. And I don't think that's a smart decision. If you put him on bond, I would say a drug patch would be smart. A GPS would be smart, but ultimately, Your Honor, it's up to you, but I don't think a bond is a smart decision.
Yeah, I don't either.
Can I have?
You may, go
can I
ahead.
ask a question? When did you place him on JCDI? Do you have a date of this time? When was he actually placed? Was it 2019 when he was placed on probation?
For probation?
Yes.
2019, May 13th.
When did you place him on JCDI? Was it just recently?
Yes, sir. It was in the last.
February of 2025.
Okay, so what changed between 2019 and February 25 to say now you need JCDI?
His drug intake went up. We've tested on multiple occasions. He's tested positive for cocaine on multiple occasions. And we believe outpatient would be the best for him. He had spoken to me briefly as well that he had, some issues he wanted to talk through. He had some family issues he wanted to talk through. So we've got him being in front of a counselor, him getting the drug treatment is what he needed. He agreed with us, that's what he needed. So he believes that outpatient program is the best option for him.
Did he go to JCDF?
He did test positive on multiple occasions. He drank at one point and he admitted that to us.
So when did he stop going to JCDF, or was he still going at the time of this offense?
He was still going at the time of the offense, but since he picked up a new offense, they had to drop him from that program.
So it was the new offense that dropped him, and it wasn't him not going?
As well as the drug use.
And was there another program too that you said?
He had done ISF, cognitive track.
And what is that?
It is, the interesting facility that we send people to, about 90 days long, and he went the cognitive track, so the thinking track.
And roughly when was that?
March of 2024.
Thank you.
All right, anything else, Mr. Burbank?
Mr. Byerly, you've heard what the probation officer said. Did you talk to the probation officer?
Yes, sir.
Speak up so we can hear you.
Yes, sir.
If the court was to allow bond, what is your plan in reference to what you would do when you got out?
As far as my plan, I mentioned to my probation officer, and I mentioned also to you that I would like to get into an outpatient program at that rate choice if possible, which will allow me to, I just told you that I couldn't work out of the county. The reason why I asked for that was because I'm working at minimum 1,000 hours less than I normally work.
You are a longshoreman, is that
Yes,
correct?
yes, sir, I am a longshoreman.
And the incident in reference to the assault had to deal with your supervisor at the port, is that correct?
Yes, sir, it is.
And so the only ports that you know of are either Houston, Corpus Christi, or Louisiana that you would go
I
to.
work at, and as far as making my payments and getting back on track, I had a stroke last year.
I'm not worried about your payments.
Yes, ma'am.
You had a stroke last year?
Yes, ma'am.
And you're still testing positive for drugs after having a stroke.
Yes, ma'am.
Okay. All right.
That's my excuse, but that's my daughter.
Do you have a place to stay?
Yes, I do.
And where is that?
Two was apartments, Mosaic Apartments is where I live.
Who stays with you?
No, I live by myself.
Who would supervise you? Do you have any family?
Yes, I do have
What
family.
family do you have?
My sister, it's Clay Byerly, also my mother, Byerly, and uncle, Christopher Williams.
And how far away do they live?
Well, as far as my mother and my sister, they live in Houston. As far as a good friend of mine, she lives right there in Fort Austin, Martin Frazier.
Do you have any kids?
Yes, sir.
Where are they?
I have one in, she's a cheerleading coach at Iowa State University. My son is in, I have two kids here in Beaumont. The one that I'm not allowed to see, and then also Tristan. I'm just reconnecting with Tristan and my 11-year-old.
Mr. Byerly, just one last question.
Yes, sir.
How can you guarantee this court, if released, that you wouldn't be taking either alcohol or drugs pending the outcome of this hearing?
Well, for one,
What guarantees?
I would accept that offer of the batch. And I can guarantee, I just want to get back to work. What I do is only go to work and come home.
You do other things, because you've done other things.
Yes, I have.
So what's the guarantee that says you're not gonna do those other things when you're doing work and going home?
At this particular time, offer my word, the past doesn't.
That's right.
Yes, and that's what I told you, I see this as my last opportunity to keep everything that I have and not have to test.
One of the things is that you tested positive. What date was that, Your Honor? On
I don't know, Mr. Burbank. What date is it?
Now, I was wondering what date it was on the allegation.
There's a date of April, if I may.
Go
April
ahead.
29th, April
Did you
15th.
test positive for alcohol back on that day?
Yes, I did.
And was there a date also of positive for cocaine? Was there? Yeah, there was. So those allegations are true, correct? If the court is not considering a bond and that he needs help, he has pled true, Your Honor, to testing dirty at this point.
Well, he hadn't pled, we're not sworn in, or, I mean, if he wants to plead to the motion, we can take care of that. With regard to the bond, the allegations, at least for that new offense on May 29th of this year, is that approximately 3:00 in the morning, 3:20 in the morning, you were sitting in a running vehicle in an empty parking lot in an area known for prostitution and drug use. You roll down the window to speak to officers. White smoke comes out of the vehicle. You get out. You got crack pipe, allegedly. 4 pieces of crack were found on you allegedly. My fear is that I don't know whose car you were in, but obviously it's scary to think that you're out possibly driving in the middle of the night, either finding drugs, using drugs in the wrong area after this is your 5th administrative hearing. So you've already been given 4 opportunities with probation without having come in front of me on an MTRP. They've gone so far above by letting you work out things administratively with ISF, with JCDI, and I approved those things, but they did those things without saying, let's revoke his probation. Let's work with them. Let's work with them. Let's work with them. And then here we are, while you're in supposedly the JCDI program, which is exactly what you say today you're asking for, outpatient treatment program. Based on the underlying offenses and the nature of those offenses, based on the nature of the 2 pending charges against you, I am going to find that setting a bond is not in the best interest in these cases of our community. I am going to leave it at no bond in these cases. We can handle this a couple ways. We can go through the motion. We can get pleas of true or not true. We can set it for a hearing for sentencing. If, depending on what the plea is on the, excuse me, the new charge of possession, we can get with the lab and I can ask them to get that done before that hearing. We can take care of that at that hearing.
Right, I'm advising not to enter a plea in reference to the new offenses until we know exactly what it is. And
That's fine.
there may be a question
I
on
think
that.
we can get that taken care of if I make that special request that they get that done in time. Do you want to go through the motion today?
Besides the new offenses, yeah.
Well, I'm going to go through the whole motion. He can enter pleas of true or not true.
Okay.
Mr. Byerly, raise your right hand the best you can. Excuse me. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, let me get this pulled up that way. I think I can do it. So will he waive the formal reading of the motion?
Be well, Your Honor.
It's mine, Judge. I'm trying to turn it off.
Mr. Byerly, in 18-28800, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, and that was a 10-year deferred probation for violation of a bond or protective order. And is that correct? And then in cause number 18-29063, that's what I need, thanks. Correct. I also have a first amended motion to revoke your unadjudicated probation. It also shows that you were placed on probation May 13th of 2019 for the offense of violating a bond or a protective order, 3rd-degree felony, and that was a 10-year deferred probation. Is that also correct? Both of these motions allege that you violated your probation. Count 1 alleges that you committed the new offense of assault April 21st of 2025 in Jefferson County, Texas. And is that true or not true? Count 2 alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates. And is that true or not true? Count 3 alleges in each case that you failed to provide verification of attending the JCDI program as ordered. Is that true or not true? Well, he was attending, but you were discharged. So I'm going to put not treated the way that one is worded. Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances and that you provided a sample that tested positive for alcohol April 15th of 2025. And is that true or not true? Speak up, please. Count 5 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true? Count 6 alleges that you possessed a drug, crack cocaine, May 29th of 2025. Is that true or not true? Count 7 alleges that you were at a location other than your residence at approximately 3:19 a.m., May 29th of 2025. And is that true or not true? Did you enter your pleas of true to counts 2, 4, and 7 freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 2, 4, and 7 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing, ask probation to do an updated pre-sentence report, ask the state to bring any witnesses with regard to those other cases. We will set it at 11 o'clock probably, but we don't need a bunch of time, do we, on a regular day? We'll just do it at 11 o'clock. And if you need me to call the lab for any reason to make sure that that gets done as quickly as possible so that Mr. Burbank has notice of those results, then just let me know and I'll help take care of that if we can get that expedited. All right, we'll see y'all back at sentencing. Yes, sir. Thank you. Give me just a second. Well, I had it up here and I had other stuff here. I had some of it. It's hard to have them both pulled up and. Okay, yes, ma'am. What was it, 2, 4, and 7? He pled 2, 4, and 7.
All but the new allegations.
Yeah. Got it.
Well, the 2 allegations of it. And then there was one in reference to JCDI.
Got it. 2, 4, and 7. Okay. All right. Brandon Dodd, Mr. Burbank. Good morning. Are you Brandon Dodd? And this is 242418. Mr. Dodd is charged with murder. And Mr. Burbank, what is the announcement?
We have been, as you know, I'm the second or maybe third attorney, second attorney on this. Just retained. I'm just asking for one more reset. We're almost up to speed. There were some questions I've gone over and talked at length with Mr. Dodd and just requesting more time. There is a co-defendant, but that doesn't make no difference.
Okay.
No objection, Judge.
All right, and so what I'll do, yeah, it looks like you've just been on it a short amount of time. Mr. Dodd, I'm going to reset your case one more time so you and Mr. Burbank can make sure you're both up to speed on everything that he's got, negotiations, and then we'll see if we can get an announcement at that next court date. All right, you can go back with the bailiff. See, is Mr. Kurtz? Yes, sir. Thank you. Mr. Kimler. Mr. LeBlanc, you've got Linton Arsenault. Did I pass my, I hate that. I get those, it was one of those tickles that wasn't getting. I know, I've got water and it's just one of those that gets you. Yeah. Good morning, sir. Are you Linton Arsenault? And this is 242190. Mr. Arsenault is charged with failure to comply with sex offender registration requirements. Mr. LeBlanc, what is the announcement?
I've gone over everything with him, and we thought I need to talk to Mr. Humphrey regarding the account offer. I believe it's going to be something we'll have
You believe it'll be what?
It'll be something that worked out, I think.
Okay, and Mr. Hoffpower's out this week, but he'll be back next week, right?
Yes, Judge, and Mr. LeBlanc did come and get the media.
Okay.
For this case as well.
Good.
I just have not discussed the offer with him. I'm happy to
Sure.
do so.
So what I'm gonna do, Mr. Arsenault, is reset your case, one more time, and it'll be that last reset. That'll give Mr. LeBlanc time to talk to the district attorney's office, make sure whatever offers they have, any negotiation is complete, make sure you've seen everything they have, and then we'll get an announcement at the next court date. Okay? Thank you, sir. You can go back with the bailiff. Thank you, Mr. LeBlanc. I don't know. I mean, I'm not opposed just because he would have to do all of that. And I want the new case indicted and part of the deal, not just to go away.
Right.
You know what I mean? I think.
It shows the lab is already in progress, so we'll just stay the course. And
I mean,
see
that's
where it
clearly
gets
what he
to.
needs. So I'm not opposed to it, but he's gonna have to take some responsibility for all that.
Okay.
Yeah. Let's see, Mr. Matuska, you've got Xavier Garner. Good morning. Are you Xavier Garner?
Yes, ma'am.
And Mr. Garner has 4 cases, and 230957, harassment by a person in a correctional facility, 242322, aggravated sexual assault of a child, 242323, and 2324, indecency with a child. And Mr. Matuska, what is the announcement?
Your Honor, I've been able to collect most of the discovery, still trying to get some of the digital media. I do expect this case to be placed on the trial docket. I just need to get the digital media.
Okay.
I've talked to Mr. Nichols about that, and that should be shortly.
We did speak, Your Honor, but I've been out the last few days, so I wasn't able to get that resolved for him this time around.
Okay.
I think it shouldn't be hard to get it for him, make sure he has everything.
Okay, so I'll do one more reset, and this will be the last reset. Y'all make sure you visit about all of that. Mr. Garner, what I have here is a pile of jail incident reports. So I want you to make sure you know that I know everything you're doing in court. And if this goes to trial, a jury will know everything that you're doing in our jail. Do you understand that?
Yes, ma'am.
You're fighting, you are talking back in an extremely ugly way to the correctional officers who are just there trying to do their job. That's their job. They're just going to work every day. They don't need to hear this crap from you every day. Every single day you're talking back, you're calling names, you're not following the rules. You want to do it your way. When you're in jail, you don't get to do it your way. And if you do continue to do it your way, you're going to end up with another harassment of a public servant in a correctional facility. You're going to end up with more time if you get found guilty because a jury is going to be mad because they're going to hear about all these things. So I want you to stop and I want you to understand, and I've been telling every one of you, how old are you?
22.
22 years old. It's all of you young kids out there acting like absolute heathens. So if you want your life to get better, you tell the rest of them, hey, I'm not going to get in trouble anymore. Y'all do what you're going to do. But running up on people, stealing their food, calling names, it's only going to get you in more trouble. All right?
Yes, ma'am.
Go back with the bailiff. And we reset Ms. Broussard for Mr. Nix, correct? Mr. Rennick, you have did I see Mr. Rennick?
Yes. We're working on it.
Okay.
He's got something.
Mr. Joel here? What about Mr. Vasquez, are you ready to announce on Veronica Randall?
Can we hold on that, Your Honor?
Sure. Okay. And what about Mr. West? Mr. Rojas, are you ready on Lawrence Jackson?
I don't think we need him out to ask for a reset on him. He wants to look at the videos on that new DWI.
Okay. And you've already got them? You just need to go out there and visit?
Yeah.
Okay. We'll just, on Lawrence Jackson, we're going to reset Lawrence Jackson for you to go show him those videos, and we'll get an announcement at the next one. Thank you. Mr. Parker, you have Cortland Pender.
I don't know, well, I don't know if we need him, Judge. I think Mr. Coleman's gonna confirm that, there's 3 cases in the motion that have been, my client claims they've been dismissed, and I think if we can reset 1 week to
My
confirm that.
understanding that they're out of Dallas County doing it, so sometime.
Okay.
So we can.
Let's do.
Oh,
Do you want to, how are we next week on? I don't know, the next week maybe just as, all right, let's just do 1 week on Cortland Pender. And then you've got Esker Boykin, Mr. Parker?
We have a Plea ready.
Okay.
Well, you-
Oh, that goes in that other file I was. Okay. Did we already do something on this? And then
He was evaluated. We started to, and we chose to have him evaluated.
Okay. Good morning. Are you Esker Boykin Jr.? And this is 250351. I'm going to take judicial notice of the court's file. Mr. Boykin was examined by Dr. Krapon for competency to stand trial. I received that report dated May 21st of 2025. The finding in that report is that Mr. Boykin is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Parker?
No, Your Honor.
Mr. Coleman?
Not from the state, Judge.
All right, then at this time, I am going to find that Mr. Boykin is competent to stand trial. Mr. Parker, will he waive the formal reading of the indictment?
He will, Your Honor, and just for the court record, he's pleading to a lesser included.
Thank you, I see that. All right, so Mr. Boykin, in cause number 25, DCCR 0351, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that is from March 5th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please. And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind. Do you understand?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. Did you have something? I'm sorry. All right, Mr. Boykin, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor assault. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. Good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you. Veronica Randall, Mr. Vasquez, Ms. Malfino.
Good morning, ma'am.
Good morning.
Thank you for smiling.
Good morning, ma'am. You're Veronica Randall. And Ms. Randall has two cases, 250246 and 0247. Both are theft of property with previous convictions. And Mr. Vasquez, what is the announcement?
Judge, could we ask for a short reset? I need to, Ms. Morfino's made a reasonable offer, but I need to do some research in Ms. Randall's case.
All right, and
Judge, I think this is Mr. Vasquez's first setting on this. Previous
I
setting,
see
you
that.
asked me to kind of map the indictment. It's so many priors that it almost makes you cross-eyed.
yes,
I think we just have a friendly disagreement on what level it is. The offer as I have made for 4 years, TDC would be valid if it was either a third or a second. Mr. Vasquez's position is that it's a state jail. I will go back and look at it again. That is not my position. I will have another set of eyes on it, because like I said, it's so much, it gets tangled up, but
And Your Honor,
regardless, I think it's at the very least a third, if not a second.
thank
okay.
you, Ms. Morfino, for your explanation. I'm sure I'll be in agreement, Your Honor. I'm just not certain right now,
Okay,
and I'm supposed to know these things.
that's okay. So what I'm gonna do is one more reset. This will be the last one. Y'all take a look at all of it and all the priors and get that worked out. And then we'll get an announcement at the next court date. Either it's gonna get worked out with the plea or it's gonna go in the trial docket. So Ms. Randall, I want you to know that I receive jail incident reports. So everything that happens out at the jail, I get a report of. The assistant district attorney gets it, your attorney gets it. If you want me to accept any plea agreement later, this behavior needs to change. If you go in front of a jury, they're gonna see these things. So you've got to follow the rules. If you want any benefit from any of us or a jury, you've got to show us that you can follow the rules and not continue what you've been doing in that jail. Do you understand? You're too old for this behavior, right? A lot of times I'm having this conversation with my 18, 19, 20, 21-year-old boys. That's who's acting up in the jail, not you. All right? So stop this, because everybody's going to know what you're doing. All right? Okay, we'll see you at the next court date. You can go back with the bailiff.
Thank you, Your Honor.
2 weeks ago. I just popped up on my phone.
Awesome. Good for him.
Sorry, I don't.
Philip,
2 weeks. Oh, here. Sorry.
I'll just tell him.
Thank you.
Looks like you got pleading on two, correct? Thank you. Ah. That's what I spent my afternoon doing yesterday, was reading jail reports. I spent more time on jail reports than I did PSIs.
They're more voluminous.
Same names I keep saying. Let's see, so we are going on the MTRP in one new case. Let's go with this new case 25. Good morning. Are you Jacqueline Young? And Mr. Lewis, will your client waive the formal reading of the indictment and the motion?
He does, Judge.
Mr. Young, in cause number 250309, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from February 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up. And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Speak up. Because let me tell you something. I bet you're not talking that low when you're acting up like all these jail incident reports tell me. When you're calling names and you're acting a fool out at the jail. So use your big boy voice and answer my questions, just like you do when you're acting nonsense to those correctional officers out there. Because I bet you're not whispering to them, are you? Are you? Okay. Because how you act at the jail, how you act right now, all determines whether I even go along with this plea agreement. I don't have to. You're on a probation. I don't have to take plea agreements on any probations. If I find that you violated your probation, I can give you anything I want to in that range of punishment. And I can say, you know what, I'm not going to let you guys negotiate. That I don't have to do that legally. So you better be careful with your faces and your words and your attitude, because I've read all of these and I already don't have a good feeling. Do you understand? So you need to give me a better feeling if you want me to go along with this plea agreement. Does that make sense? Okay. So again, before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in that case?
No objection, Judge.
It's admitted. Is there any evidence that Mr. Young is not competent?
No, Judge.
All right, so I'm going to find that you entered a plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Now, in cause number 2137857,
Your Honor, it's a second amended, just in the interest of economy, I would suggest we go forward on counts 1, 2, and 13, 13 being the offense he's already pled to.
okay, let me look at it. Thank you. I got it, thank you. So I have a second amended motion to revoke your community supervision. So you're on probation. We've got a probation for an evading arrest or detention with the use of a vehicle. And we've got 2 more evading arrest or detention?
The second evading is a misdemeanor enhanced to a state jail. And
Oh, it
count
was-
20
right.
reads motor vehicle. That's incorrect, Judge. It's evading on foot
Okay.
with priors.
Okay, gotcha. So this shows that you were placed on probation August 29th of 2022 for evading with a vehicle. And that was a 10-year sentence in prison that was probated for 5 years. Is that correct? And the state's elected to proceed on counts 1, 2, and 13. Count 1 alleges that you failed to report as directed to the probation department on October 2nd of 2024. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? And then count 13 alleges that you were arrested for the offense of evading arrest or detention with the use of a vehicle February 26th of 2025. And is that true or not true? What's the status of the possession and the failure to ID from that date?
I believe the failure is, I think, still pending.
The failure ID is still pending next door.
And examining the probable cause affidavit from that date, I don't see that there would be a possession charge, Your Honor.
Okay.
I will double check and see if there's, I didn't see anything else that like filed or pending. At this point, I'll check and see if there's a lab report pending, but I don't think that's been filed.
Okay. Let me look at something real quick. What I'm looking at, just so that you know, I'm trying to go back and find which administrative hearing talks about the allegation of his behavior to, it looks like there was something that happened with probation. One of the allegations, so I want to see a little more about that. That coupled with what's been going on in our jail may or may not affect my same thing. It's the same thing. You did the same thing to your probation officer that you're doing in the jail. Do you really think that your probation officer is going to go on a date with you? Do you really think that a correctional officer is going to go, yeah, when you get out of jail, you're the guy I want to date? You got in trouble for saying and talking like that to your probation officer, and now you're doing it when you're in jail. Cursed loudly about the work you had to do for your community service, calling it slavery. You think community service is slavery? Do you think that? It's the same. I'm not taking 5 on the MTRP. I've already taken 5 on the other. Y'all can renegotiate or you can let me do it. So I'll hold everything right now. Y'all go visit some more, but that's the same behavior. We're not gonna reward that. All right, y'all go visit. I'll hold it instead of resetting it. I'll keep this paperwork, but I can make a modification if you come up with something different, but I'm not gonna do that. Let's see, so I already did that one. There goes something else probably going out to everybody. Now my computer's stuck. Are they? It just, yeah, it's not letting me do anything. Oh, it just let me do something. But I thought I sent this one to you. Let me double check why it didn't go. So that one's done. Did I print out the certification on 0309? Do you see it? Here, I'm printing it out now again, just in case I can close it. Because I did already do that one, so. All right, so what about, Mr. Lou? Oh, is he back there? Let's see, I'll skip that one and go to, Ms. Holmes, you got a Prestavian Westbrook. Are you ready on that?
Can I get a minute on that? I'm ready on.
What about John Wade? It's a
Yes.
sentencing. Let's get
Yes.
John Wade.
Let me get my tab.
Oh, good. One that doesn't have any issues.
I've got a check mark on mine.
Huh?
I've got a check mark.
I do too. And it's so nice to see that. We're talking about how nice it is to see that on the front of ours
Yeah.
instead of all the colorful markings,
Yeah.
the rainbow markings. Good morning, sir. Are you John Wade?
I am.
And Mr. Wade was previously in court, entered a plea of guilty to evading detention with a motor vehicle. This is cause number 250027. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, sir.
Are there any additions or corrections?
Not from the defense, Your Honor.
Not from the state.
All right, Mr. Wade, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is dismissed. You'll never be a convicted felon. The other side of that is if you violate any conditions of probation, you can be brought back into court. You could be convicted of the offense and sentenced to prison for up to 10 years. Do you understand?
I understand.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.
Thank you much.
Yes, sir. Jamie Story.
Yes. That, yeah.
Jamie Story.
I'm just gonna enter, please.
Okay.
True.
And set it for hearing?
Yeah.
Okay.
Well, I think it's just, I think she's not contesting. I just think we probably need the court to maybe determine the amount of time
Okay.
on the revocation.
We'll get an updated report. Okay. You would think that word would start getting out there about the behavior and that there's actual consequences. Oh,
Oh,
yeah.
And I just chewed him out back there. So
Well,
yeah,
he's cheap. Good morning. Are you Jamie Story? And Ms. Holmes, will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Story, the best you can, would you raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, ma'am. You can put your hand down. And this is cause number 231546. And in that case, Ms. Story, I have a motion to revoke your community supervision. Shows that you were placed on probation February 25th of 2025 for the offense of theft of property, a state jail felony, and that was, and I guess there must have been some priors as well because it was a 10-year sentence that was probated for 10 years. Is that correct?
I noted back in May 24, she pled to the full indictment, which made it at that point in time 33.
Thank you, Ms. Malfino. The motion alleges that you violated your probation. Count 1 alleges that you violated because you failed to report to the probation office as ordered February 28th of 2025. And is that true or not true? I'm sorry, speak up, please. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you failed to immediately report to the probation officer your contact information. Is that true or not true? Okay. Count 4 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? Count 5 alleges that you failed to complete the mental health evaluation and follow any recommendations of that. Is that true or not true? Count 6 alleges that you failed to provide verification of completing the theft prevention class. And is that true or not true? And then finally, count 7 alleges that you are behind in your court assessed fees just by $100. Is that true or not true? Did you enter your pleas of true to counts 1 through 7 freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for a sentencing hearing. Ask the probation department to do an updated report that'll give me more information about what's been going on while you've been on probation. Anything that you think is important for me to know, get that information, excuse me, to Ms. Holmes, and she'll present it to me on your behalf when we come back. I did that. I didn't like to last night. Okay. It's unagreed. Yes, ma'am. Let's see, Miss Holmes, you have Stephanie Martin.
Judge, I'm working on the paperwork. The cabinet was.
Okay, I'll hold that until that's ready. Thanks. And Daniel Martin, is he in, is she in the back? Is Miss Holmes working on something in the back?
She was in the back.
On Daniel Martin?
Yes, Your Honor.
You good over there?
Yeah.
Do y'all need a minute?
So, can you go on?
Uh-huh. Jamel Caddy, Ms. Holmes.
We could hold that one.
I'm gonna hold it. Christopher Bushnell. Oh, yeah. Christopher Bushnell. Mhm.
Came back to sentencing and my notes say he rejected it.
Okay.
So there is that on the side. So they were expecting.
I guess so.
to be
I must have
sentenced,
forgot
but
to.
my notes say everywhere that he rejected.
Oh, yeah.
But it doesn't say that on there. I wrote that.
Oh, okay.
So they did not.
All right, you're Christopher Bushnell? And so Mr. Bushnell has two cases, an evading arrest or detention with a motor vehicle and engaging in organized criminal activity, and cause numbers 25-0112 and 0113. There was previously an agreement, motion, I'm sorry, a plea agreement for 10-year deferred probation. We were here because of the issues in the jail. I rejected that because if I were going to go along with that, I was going to order the ISF. And so we're back here. And then, so let me ask you, I should tell you what's bad is when I remember stuff, Mr. Bushnell. Your birthday's in October, right? No, December. So, so we're getting close, but here's the problem, Mr. Bushnell. So you were here May 6th, right? And I didn't accept these plea agreements, and I got pretty upset with you because of what had been going on in jail, right? And what did I tell you?
Back with no write-ups.
You know how many write-ups you've gotten since May 6th? You want to take a guess? Too many to count. Too many to count. May 6th, you got, since then, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 11 more. Fighting, same things. Fighting, not following the rules, calling names. I mean, same thing. You don't like following rules, do you?
I do.
You do? What part of calling a correctional officer the names that you've been calling is appropriate? It's not. So why would you keep doing it after I told you? I told you, go just be good for a month. 1 month, be good, follow the rules. And it's one thing if you've got another inmate running up on you fighting and that was your excuse, but it's not. I'm not accepting any plea agreements. If the jury wants to see all this and give you probation after that, that's going to be up to them. I'm not doing it. Go back with the bailiff. We'll set your case for, well, let me do this. Ms. Holmes has been appointed as your attorney, and she's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. What I can do is release her and appoint a new attorney who can begin preparation for trial. Do you want me to do that? Or do you want to keep Ms. Holmes? All right, Ms. Holmes, get ready for trial. And let me tell you what you're doing. You're making her job hard. She's trying to help you. I wanted to try to help you. If you came in today and didn't have all this nonsense, calling, I mean, I'm looking at it over and over, calling them the B word, not doing what you're supposed to, saying, I don't care, write me up, I don't care. If you don't care, then I don't care. Because I tried last time when we had this conversation. So your case is going on the trial docket, and again, we'll let a jury decide what to do with you. Go back with the bailiff. Good luck, Ms. Holmes. Chad Holland, Ms. Minaldi. Is that a plea?
Yes, it
Okay,
is.
as soon as it comes through, I'll take care of it.
Thank you.
It's not here yet. Thank you, ma'am. Mr. Kimler, you have Marissa Tibbetts, 3 cases.
That's gonna be a plea on the 2 and 4 that just said violation.
Have you already, did you do paperwork?
I haven't. There's no agreement.
Okay. Please, I guess that would be easier.
Sure.
And what about the new case?
On that's part of the NCRP, just carry it with the NCRP. I think there's a non-prosecution. I don't want to speak to the attorneys, Mr. Smith's case, but I think he's going to communication with the where his office is.
All right, hold on a second. Mr. Smith, on Marissa Tibbetts.
Yes, ma'am. Did Rod tell you on these, we're just gonna go through the motions?
Yes.
Do the motion.
And I would think, well, there's 2 motions. And then I would assume, is your intention to prove up the other one, or is there some issue?
If we can, I need to get hold of the.
So we'll set it for a time when there's a little bit of time then?
Just a little bit.
So a regular docket day, or maybe somewhere where you have a little more? Good morning. Are you Marissa Tibbetts?
Yes, ma'am.
And will your client waive the formal reading of the motion in each of her cases?
She would,
Okay, Ms. Tibbetts, in cause number 1828, well, before we do that, raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And Ms. Tibbetts, excuse me, I have in cause number 18-28754, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2018 for the offense of aggravated robbery, a first-degree felony, and that was a 10-year deferred probation. Is that correct? And then in cause number 18-28753, I also have a motion to revoke your unadjudicated probation. It shows you were placed on probation October 29th of 2018 for aggravated robbery, a first-degree felony. Again, that was a 10-year deferred probation. Is that correct? Each of these motions allege that you violated your probation. Count 1 in each motion alleges that you committed the offense of burglary of a building March 22nd of 2025 in Jefferson County, Texas. And is that true or not true?
No, ma'am. Not true.
Count 2 in each case alleges that you provided a urine sample March 18th of 2025 that tested positive for methamphetamines and marijuana. And is that true or not true? True or not true?
True.
Count 3 in each of the cases alleges that you were at a location other than your residence at 11:15 p.m. March 22nd of 2025. And is that true or not true? I'm sorry?
No.
Okay. Count 4 in each case alleges that you are behind in your court-assessed fees, and it's just a little bit in each case, $29 in one and $37 in the other. Is that true or not true?
Yes, true.
Did you enter your pleas of true in each of the cases to counts 2 and 4 freely and voluntarily? The counts that you pled true to, 2 and 4, did you do that voluntarily?
Yes, ma'am.
And did you plead true to those counts because those 2 are actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 2 and 4 freely and voluntarily. Find those counts true, find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your cases for a hearing. The state on that date, if they want, can put on evidence with regard to any other allegations. And anything that you think is important for me to know, get that information to Mr. Kimler. He will present it to me on your behalf when we come back. I'll also get probation to do an updated report as well. All right, you can go back with the bailiff.
Your Honor, if I may, this is deferred. I think the court has set bonds in the cases. They're relatively high. I believe they're.
Do you want to file a motion for, if I've already had a hearing with another attorney, I don't, unless there's some change of circumstances, I don't, we're not going to do that today for sure. But I would need some change of circumstance if I've already had a hearing.
When the reset was, can we get a speedy reset? Your Honor?
You're going to get the same reset on a motion that we get so that everybody can get prepared and so that that updated report can get taken care of.
I'll be out to see you.
Just at 11. What? Yes, ma'am. Yes, absolutely. So another one at 11, I know. And there might be, you know what, if we're loading this up at 11, there might be a week when we're not, just, let's look at it, because I can set it on at 1 on a week when we don't have a jury also, you know, so that we don't load up or have to put it too far off. So just make a note, we can look at it if you think that's, okay. Let's see, what else does Mr. Lewis have? Mr. Lewis, on Brandon Chillo, what are we doing on that? Are you ready? That's the MTRP sentencing. Well, I just did it. I just did the. I know. You can tell when it's. Morning. How are you?
Good.
Good. Good morning, sir. You are Brandon Chillo? And in cause numbers, or in cause number, I'm sorry. Is there 2 cases? Yeah. 19-32403 and 19-32404. Mr. Simon, good grief. Sorry, Miss Simon. Mr. Chillo is on probation in each of those cases, was here previously and entered pleas of true to motion to revoke probation to counts 1, 2, 3, 5, and 7. I've received an updated report, and has everyone had an opportunity to review that report?
Yes.
Any additions or corrections to that report?
Nothing to finish.
Judge, the only thing I have is, in speaking with Mr. Hoffbauer last week, it was not his position, I don't believe, to put on any additional evidence because of the fact that Mr. Chillo pled true to count 1. The others just kind of actually patterned that, and based on Ms. Simon's recommendation of continuing him on probation with JCDI. We don't have evidence of that. If the court needs it, we can get it. But I
No,
believe
are
that
y'all
case
in
has been
agreement
filed.
with that recommendation, Ms. Muffino?
Ms. Simon is.
And Ms. Simon, that's still your recommendation? You believe that, it looks like for the most part, Mr. Chillo, you've been doing everything you're supposed to, especially on the type of probation you're on, which is great, and that gives me less concern, but it looks like There have been some issues specifically with some drug usage that you need some help for, and probation is willing to give you that help and keep you on probation. I want to make sure you understand, if I go along with this today and continue you on probation, and if you violate again in any way, it is probably not going to go as well as it's going to today. Do you understand?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, 3, 5, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation in each of your cases in order that as a condition of that probation, you enter and successfully complete the JCDI program. You will be on the high medium caseload, so you're going to be going to probation more often. You're going to be going to JCDI. If you test positive, if you continue to violate in any way, you're going to be back in here. And again, we're not going to have such a nice conversation. Do you understand?
Yes,
What you're on probation for is extremely serious. I appreciate that you're doing that part of your probation well, but I want to make sure you know you have to do all of it. Okay? All right. Good luck to you, sir. Thank you, Ms. Simon.
Thank you.
Thank you, Mr. Lewis. Let's see. What about Jacqueline Young? Did y'all talk?
I just got word. Let me check on that.
Go ahead. Okay. And Ms. Minaldi on Chad Holland?
Chad Holland. Good morning, Judge.
Good morning, ma'am. How are you?
I'm doing good.
And so we're going on all of the,
Just paragraphs 1 and 2, Judge, we're increasing it to a second degree felony for the range of punishment.
okay. Let me get that pulled. Okay, okay. Thank you. Good morning, sir. Are you Chad Holland? And Mr. Holland, Ms. Minaldi's here. I know she's visited with you this morning on behalf of Mr. Gertson. Are you fine going forward with your plea this morning with Ms. Minaldi? Thank you. And will your client waive the formal reading of the indictment?
Yes, Judge.
Your Honor, for the record state, we'll proceed on counts 1 and 2, and we'll abandon the remaining enhancement.
Thank you, Mr. Coleman. Mr. Holland, in cause number 24, DCCR 1616, the state is elected to proceed on counts 1 and 2. Count 1 is the offense that you're charged with, which is fraudulently securing a document by exception, or by execution, and that's from December 30th of 2023. Count 2 alleges you were previously convicted of burglary of a habitation March 15th of 2004. And how do you plead to that charge? And is that prior conviction true? Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Minaldi? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No, Judge.
It's admitted. Is there any evidence that Mr. Holland is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of fraudulently securing documents by execution. Also find that prior offense true. Sentence you in accordance with your agreement to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Miss Minaldi or Mr. Gertz. Do you have your discovery certification?
She gave it to me, I'm sorry.
Okay, all right, good luck to you, sir. You can go back with the bailiff. Thank you, Miss Minaldi.
May I excuse you?
Yes, ma'am.
Thank you.
Excuse me, Judge.
Yes, sir.
We have to do it for you.
Okay, and are y'all good with just me making a modification on what I've got here?
Right.
Let me find it again. All right, let's get Mr. Young back out. All right, so we are back on the record in cause number 21-37857. And again, you're Jacqueline Young, right? And in that case, which is the motion to revoke probation, Mr. Young had entered pleas of true to counts 1, 2, and 13. There was an agreement for 5 years in the institutional division, which I said I would not accept. Have you guys had an opportunity to visit?
We have, Judge.
And what is the,
The new agreement is 8 years TDC.
all right, I'll take that. And Mr. Nichols, that's your agreement as well?
Yes, Your Honor.
All right, Mr. Young, again, I have some documents here, like the other case, that have your signature on them, that the state's marked as exhibit number 1. And before you signed these, did you go over them with Mr. Lewis? Speak up. And do you fully understand them also? And I have made the notation with everyone's agreement on the agreed punishment recommendation page that that's changed from 5 to the 8.
Yes, ma'am.
Yes, Your Honor. Thank you.
All right. State tenders number 1 in that case?
No objection.
It's admitted. And so, Mr. Young, I'm going to find that you entered your pleas of true to counts 1, 2, and 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with this agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. As a part of this plea agreement, I'm going to sign a dismissal in cause number 25 DCCR 0385. I'm handing you in each of those cases the trial court certifications that shows that these were agreements that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. When you were here back in 2022, we went over the fact that you're not supposed to possess a firearm in Texas, correct?
Yeah.
Okay. It can still go worse. I mean, I got 2 more years. It's not, I mean, it's not funny. It's not funny to you, but I know you're upset about all this, but the only person you should be upset with is yourself, you know? So anyway, because of the judgment entered against you, you're not allowed to possess a firearm in Texas. I've handed you that admonishment. Be sure and read it again. We already went over it before. All right, good luck to you. You can go back with the bailiff. I need some sharing time. I did it again. Y'all got to make me stop. I just did my mouth thing again, my frustrated thing that they keep catching me off. I can't help it. That's what I do when I'm frustrated. Look, my face is turning red right now. I don't have one. I know, it's terrible. I feel like it's the worst. I need something that makes it higher.
I agree. I wonder.
They make these little tripod things. I think I need one of those if we're gonna continue this, and maybe we can move it over a side or something. Okay. Let's see, Mr. Rennick, are you ready on Tyron Henderson?
I am here.
There's no paperwork on that one, correct? Oh, yes, there is. I see. What? And did y'all do paperwork on the MTRPs? Oh, I don't have all that. Let's hold it for a second. Okay. Well, it's 3. It'll take a second. Let me keep looking at what I got here. Mr. West, what about Mr. Sinclair?
I'm doing the rejection right now, and I'll have that for you in a second.
I'm gonna need, yeah, for sure the MTRPs, all 3 of those.
There's one here.
Yeah, I don't need the new offense one, but thank you very much. All right, Tyron Henderson. Thanks. That's Jacqueline Young's. All right, good morning. Are you Tyron Henderson? And will your client waive the formal reading of the motions and the indictment?
Yes, Your Honor.
Just a second. Oh, hold on, I'm pulled up the wrong one. Go paperless, they said.
I remember in the old days, we just. voted on
I would have
paper.
already been done.
Yeah.
All right, Mr. Henderson, in cause number 25 DCCR 0520, you're charged with the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from March 23rd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rennick? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year term in prison, but that would be probated for 10 years. Is that and it would run?
That's an error, Judge. That's an.
There's no
NPR.
concurrently,
Yeah,
okay.
there's no.
So, I'm gonna mark that
Yeah,
out.
that was my mistake.
And then I guess the agreement then on the others is to continue probation.
With ISF cognitive. That was actually all of the judge.
Okay. Oh, this one as well.
Yes,
Can I make that notation?
Yes, please, Judge. I apologize. about
So
that.
the agreement is also, if I follow it, that you would enter and successfully complete the cognitive track of the ISF program. Is that your understanding? Also, do you understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number one.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Henderson is not competent?
No, Your Honor.
All right, Mr. Henderson, in 250520, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. I am going to reset your case for sentencing. I want to get some more information about what's been going on and get an updated pre-sentence report, find out more information about this case and also what's been going on probation, and we'll come back later for sentencing. And can you double check? I don't see any, so I'm assuming there weren't any. If you didn't give it to me yesterday. Perfect. We'll talk about that in a second. All right, then, Mr. Henderson, in cause number 2138934, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation August 1st of 2022 for the offense of evading arrest with a vehicle, and that was a 5-year deferred probation. Is that correct? Answer out loud, okay? And then in cause number 2239131, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 1st of 2022 for the state jail felony offense of unauthorized use of a vehicle. That was also a 5-year deferred probation. Is that correct? And then finally in 230899, I have a motion to revoke your community supervision. This shows that you were placed on probation November 27th of 2023 for theft of a property, state jail felony, and that was a 2-year term in the state jail prison, probated for 5 years. Is that correct?
Yes.
Each of these motions allege that you violated your probation. Count one, and each of these motions allege that you were arrested for the offense of evading arrest or detention with a vehicle March 23rd of 2025. And is that true or not true? Count two alleges that you were arrested for the offense of reckless driving March 23rd of 2025. And is that true or not true? Count three alleges that you have not provided verification of performing the community service hours as required. Is that true or not true? Count four alleges that you were at a location other than your residence at approximately 3:35 a.m. March 23rd of 2025. And is that true or not true? I think I'm going to keep going. I've got some concerns on this. Count five, thank you though. Count five alleges that you did not provide verification of complete, well, hold on a second. Count five, oh, they're different. Count four in two of the cases and count five in the other alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? And then count six in each case alleges you're behind in your court assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1 through 6 in each of these motions freely and voluntarily? And did you plead true to those allegations because they're all actually true? In each of these cases, I also have some documents here on the computer that have your signature on them that the state's marked as exhibit number 1. Did you also go over all of these with Mr. Rennick?
Yes.
And you fully understand them? And it looks like the agreement in all of these is for me to continue you on probation and order that you enter and successfully complete the ISF cognitive track. Is that your understanding?
Yes.
State tenders number 1.
There's no objection.
It's admitted. Is there any evidence again that Mr. Mr. Henderson's not competent?
No, Your Honor.
All right, Mr. Henderson, in each of these cases, I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty in 2 of the cases and revoke your probation, and then revoke your probation in the other case. But I'm not going to do that. I'm going to reset your cases for an updated pre-sentence report, and then we'll come back at a later date to see if I'm going to accept these plea agreements or not. I do have some current concerns, obviously. I'm sure y'all know. I mean, we've got 2 felony probations from 2022, and then that theft Was that committed while he was on probation?
It was.
It was from prior?
It was prior, he had stolen a dirt bike, I believe, Judge. And that's what always revolved the dirt bike.
But one of them wasn't indicted till much later? So we've got the two cases, the evading arrest and the unauthorized use of a vehicle. Those are both from 2022. Then we've got a theft of property from 2023 that he was put on a straight probation for. So we'll get it all figured out with the pre-sentence report, but it looks like.
That was a tailgate that was stolen from Granger Chevrolet in Orange, but he helped in recovering that.
So he was on,
It was
so,
indicted later.
but it was an offense, when was the offense date? That would be 23, I mean, well, no, that's the indictment date.
February 2nd of 23.
Okay, so on 2 felony probations, committed another felony, got an opportunity, now we have another felony. So I want to see what all's been going on before I accept these plea agreements. I can tell you one thing that you are doing good and that I hope you continue to do, unlike everybody else probably around you and wherever you are, whichever dorm you're in, is I don't have any incident reports. On paper, it does not look like I should give you this opportunity. If you continue to do well, you have a much better chance of me going along with what they've proposed to me to do, all right? Okay, go back with the, yes.
To his credit, and we're actually here to make arguments. He's acknowledged the entire time, he realizes that he is not doing what he's supposed to be doing. He's betrayed the property when anybody wants to change views.
Thank you, I appreciate that. Okay, we'll see you back at sentencing.
Are we doing a test on the new case also?
Please, ma'am, yes. Like I'm gonna start giving good deals if they can just behave. Okay. Stephanie Martin has a bunch, so if y'all want to start printing her stuff, I can.
But they're good, yeah, they're fun, they're fun.
Mr. West, on Aleem St. Clair, do you see something on him? Can y'all check for some rejections? Oh, okay. Let's take care of Aleem St. Clair, please, and then I'll take care of Miss Martin. That'll give y'all a minute to get those.
Sorry I was late, Your Honor, this morning, Your Honor. I was over in Orange and I let Anna know that I'd be
Thank
late,
you,
but I
sir.
would be here.
They did, they let me know.
Okay,
Thank you
good.
for letting us know.
Good. So I don't like to.
All right, sir, let's see, Miss Malfino, this is Aleem St. Clair.
Sorry, Judge.
That's okay. Good morning, sir. Are you Aleem St. Clair? Are you sick? What's wrong with you? When? Okay. Like you're, all right. So, Mr. St. Clair, in cause number 23, DCCR 1390, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from July 15th of 2023. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And then in cause number 23, 2117, you're charged with a first-degree felony offense of aggravated robbery from August 15th of 2023. And in that case, what that means is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand that as well? And then in cause number 23-2044, you're charged with a first-degree felony offense of aggravated robbery from August 15th of 2023. Again, that has the same punishment range if you're found guilty, which is between 5 years and up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then finally, in cause number 23-2043, you're charged with unauthorized use of a vehicle, which is a state jail felony offense. And that is from July 11th of 2023. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
In each of these cases, I have here on the computer some plea bargain rejections that you have signed with Mr. West. This shows that the district attorney's office has made an offer. So is it, what's the?
It would be a 25-year cap in both of the aggravated robberies. We had offered or discussed to dismiss that aggravated assault based on a plea in those ag robberies, as well as the UUMB. We rejected that. We went ahead and did a rejection of the 20 cap in the aggravated assault. But it was my original position to dismiss two, and if he would accept responsibility in the 2 aggravated robberies, and also not to proceed on his 3 misdemeanors. If I may, just for the record, so Mr. St. Clair is aware, now that he has rejected this, unless circumstances change, which I'll bring to the court's attention well in advance, it will be my position to ask that the sentences run consecutively.
So, Mr. St. Clair, I want to make sure you understand. It looks like what you have signed with Mr. West shows that the state's offer was for you to, if you wanted to enter a plea of guilty to the aggravated robberies, for a cap of 25 years, which means you would be leaving your punishment up to me. I could sentence you to 25. I could sentence you to less. It would depend on the information that was brought to me at a sentencing hearing. And the agreement would have been to dismiss the unauthorized use case, as well as that aggravated assault case, as well as some misdemeanors. If you go forward with trial on these cases, we'll go depending on how this all goes, because the offense dates from the aggravated robberies and they're to the same dates, but then that aggravated assault and the unauthorized use are from a different date. And what that means is that if you're convicted on those cases and sentenced by a jury, I could then stack those punishments on top of each other. And I don't know if I would do that or not. It would depend on the information that I saw during those trials. Do you understand?
Yes, ma'am.
Do you want to reject those offers and have all 4 of your cases set for trial?
Yes, ma'am. I'm trying to get a lower offer.
Pull that down a little bit.
I said I'm trying to get a lower offer.
So here's the thing, we're not negotiating anymore. Okay, the offer, Ms. Malfino just stated that the offer is what the offer is. And unless there is some new information that is received after today, I will not accept this offer after today. So today's the day to either accept this offer, or your cases will go to trial, or it will be to some offer that's different, higher, or to me open, unless there is some, again, new information that no one knows about. And is there any reason to think there would be any new information?
No, Judge, and what my position was in offering the cap that Mr. West and I discussed was to allow Mr. St. Clair to ask the court for probation. I think that's what he's trying to say. That's what he's been trying to say through his attorney. I'm not in the position to offer that. He's been in custody for some time. I think it's been explained to him that the court would take a look at everything and make a determination, but it's not my intention to offer probation, although I'm very well aware of the fact that the court could place him on probation. If that's what the court does, we'll respect that decision.
So you understand, if you plead to a cap, I can do, again, anything from probation up to 25 years in prison. I know nothing about your cases at this point. So I don't want to give you some false sense of, yeah, plea open to me and you're going to get a probation. I don't know. You could plea open to, or cap at 25 and I could give you the 25. I could give you somewhere in between. I can consider probation. I just can't know those things but right now, because I don't have any information. And if you did that, what would happen is if you wanted to enter a plea and take that deal, then we would reset your cases for sentencing. we would get a,
I ain't do this shit I did, don't know.
well, if you didn't do it, that's what a jury's for. So we'll get them set for trial, okay? All right, go back with the bailiff. We'll get them set for trial. Is Brittany back there working on something still? Okay, I'm gonna take just a short break. As soon as Ms. Holmes gets finished, we'll take care of her. I think she's got 3 remaining cases and that'll be it. Ms. Holmes? Nuh-uh. You're in court. Don't act like that.
There's plan to four cases, dismissing only one.
That's right. Concurrent.
Good morning. Are you Stephanie Martin?
Yes, ma'am.
Give me just a second, please. Will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
All right, Ms. Martin, and cause number 20. Let's see where I'm gonna start. Which one's being dismissed?
It's ending in 247, Judge.
And cause number 24, DCCR 0248. You're charged with the state jail felony offense of possession of a controlled substance from October 1st of 2023. The indictment alleges that you were previously convicted of possession of a controlled substance August 24th of 2015. And then after that was final, you were convicted of possession of a controlled substance April 11th of 2016, and also convicted of fraudulent use of identifying information on April 11th of 2016. And how do you plead to that charge?
Guilty.
And are those priors offenses true?
Yes, ma'am.
And then in cause number 23, DCCR 1850, you're charged also with the state jail felony offense of theft with previous convictions. Well, not also, but in that case, that's what you're charged with. And that's from July 14th of 2023. The indictment alleges you were previously convicted of theft August 14th of 2001, March 15th of 2006, September 8th of 2014, August 24th of 2015, April 11th of 2016, July 31st of 2018, January 28th of 2019. And then the indictment alleges those 3 prior other offenses of the possession of a controlled substance in 2 cases and that fraudulent use of identifying information. And how do you plead to that charge?
Guilty.
And are all of those prior convictions true?
Yes, ma'am.
In cause number 250376, you're charged with the state jail felony offense of theft of property with previous convictions. This offense date is from February 7th of 2025. It alleges all of those same prior theft offenses as well as the same prior state jail felony offenses. And how do you plead to that charge?
Guilty.
And again, are those prior convictions true?
Yes, ma'am.
And then finally, in cause number 250375, you're charged with the state jail felony offense of theft with previous theft convictions, and this is from February 18th of 2025. It also alleges all of those same prior theft cases as well as those other prior state jail felony cases, convictions. And how do you plead to that charge?
Guilty.
And again, are all of those prior convictions true?
Yes, ma'am.
In each of these cases, did you enter your pleas of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty in each case because you actually did what they've charged you with?
Yes, ma'am.
In all of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Martin is not competent?
No, Your Honor.
All right, Ms. Martin, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 250375, find sorry, I'm sorry, okay. In 30735, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with prior convictions. Find all of the prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 250376, also find sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions. Find all of the previous convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 23, DCCR 1850, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with previous convictions. Find all those prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit for that on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 24, DCCR 0248, also find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of possession of a controlled substance. Find all of those prior convictions true. Sentence you in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will all run concurrently, which means together at the same time.
So are we doing all this?
All of it runs at the same time, yes, ma'am. I will also sign a dismissal in 24 DCCR 0247 as part of that agreement.
Your Honor, if I may, I'm sorry. to interrupt.
Yes, sir.
The plea also contemplates the declination of prosecution of the unfiled possession of a controlled substance that appears in BPD number 2025002990.
So the state has also, as part of this agreement, agreed not to pursue that specific case. Do you understand? So there's another possession case out there that Beaumont PD has, but that they haven't, either the labs haven't been done or whatever, it hasn't been indicted yet. What they're saying is they're not going to pursue that case. So it will not be indicted. You're not gonna have to come back here and take care of that case. It's kind of like it's being dismissed before it really gets indicted. Does that make sense? Okay. Did I print all four?
Yes.
All right, so I'm going to hand you in all four of these cases, the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishments I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. Yes, ma'am.
I'm sorry, can I say one, those are my kids right there. Can I just tell them bye?
From here, yes,
I'm
ma'am.
sorry I let y'all down. And I will see y'all when I come home, okay? I love you, Mills. I love everybody.
So, Ms. St. Clair, the thing to do is to take advantage of any opportunity you have while you're in custody, so that when you do get out, you can be a part of their lives, okay?
Yes, ma'am.
All right.
See y'all in 2 and a half. I love you.
Christaven Westbrook.
Okay.
Good morning. Are you Christavian Westbrook? And will your client waive the formal reading of the indictment?
Will, Your Honor.
Mr. Westbrook, in cause number 25 DCCR 0101, you're charged with the state jail felony offense of theft of a firearm, and that is from November 15th of 2024. And how do you plead to that charge? Are you guilty or not guilty? Well, there's no, I guess, guilty. Did you do it or did you not do it?
When we say stole it, I ain't steal nothing.
Okay. Were you with some people who stole it?
No, man.
Your Honor, he bought a gun that the police checked, and the gun came back as stolen.
Okay.
The probable cause, I'm sorry to step on you, but the probable cause affidavit represents that the defendant indicated to law enforcement that he had some knowledge that it was stolen.
Let me look at that real quick. So did you know it was stolen?
No,
The
man.
gun was stolen in 2015, in which he would have been 8 years old. So he did buy the gun off the street. I mean, I guess you can feel like it might be stolen, but he was 8 years old when he found it in Hardin County. So clearly he's not the one that stole it. But it's indicted as if, he appropriated the property with the knowledge that it could have been stolen, and that's what he was indicted on.
That's the state's position.
So what you told the police was that you bought it for $250 and that you believed it was stolen because that's what other people had told you. Is that right? Okay, so if you didn't know it was, listen, if you didn't know it was stolen, no one told you it was stolen, obviously you didn't steal it because of the dates of all of that. But if you didn't know anything about it and you were just buying a gun illegally, that doesn't mean that you should plead guilty to theft of a firearm. So I want you to be careful what you say today, because when you were standing over there in front of the clerk, you put your hand up and you swore to tell the truth. And so you can't say, I just want to take this deal and get out of jail, but then stand up and say, I didn't do it. If you didn't do it and you didn't know, then that's what trials are for, and a jury can decide if you either did it or you didn't do it. But if you're in front of me and you want to take this plea agreement, it's going to be because you actually knew what was going on. So you either did or you didn't. Do you want to talk to Ms. Holmes for a minute?
Yeah.
Okay, y'all go visit for another minute, just for a minute though. Let's see, you also have, let's take care of,
Daniel Morgan. He decided to plead, Daniel.
oh, okay, what about Jamal Caddy?
We're gonna need a reset on that.
Do I need to bring him out or anything?
No, it's dealing with priors, because he potentially may be habitual.
We're gonna reset Caddy, and let's take care of Daniel Martin, and then you can go visit, with Mr. Westbrook, and if you need some time on Westbrook,
Yes,
we'll
ma'am.
reset it
Because
for,
that was my whole, I told him not to plead. I was like,
I mean, it doesn't sound like that's,
yeah.
I mean, I don't know,
I
but.
told him not to do it, but I think he just wants to get out.
Daniel Martin, yeah. Daniel Martin changed his mind. We said we were gonna reset it, but they still have
Yeah,
them?
he changed his
Okay,
mind. I'm gonna email the attachments.
thank you. All right, sir, you're Daniel Martin?
Yes, ma'am.
And, let me get this pulled up. Hold on a second.
Judge, with the court's permission, may we proceed on count one only on third degree harassment?
Yes, ma'am. Okay. And that's 0299, correct?
Yes, sir.
Okay, so Mr. Martin, in cause number 250299, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of harassment of a public servant from August 29th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they charged you with? And then in cause number 250300, you're charged, and we're going on all of them in that, we're going on,
Is that the state? jail?
yeah.
He's playing a 2-year state jail. I don't
So
know.
it's state jail only and not the
Yes.
priors in that one?
Oh, I see what you mean, Judge, the powers were making.
Second degree.
On that, that's my error, I didn't flip the page.
That's okay.
Over, I was just
So-
looking at the restitution.
Count one only?
If the court would allow, if not, I'm happy to.
Well, I mean, I guess I'll see what happens at sentencing. I mean, what's the agreement?
It's a
2
time
years
off for
state jail.
2 4-year state jail.
Oh,
It's 2 years on that one and 4 years on the other one.
and the other one, he would be habitual. Okay.
If I need to revisit the
No,
alternatives,
no,
that's-
no, no,
that's
no,
what I'm
no, no.
saying.
I just need to make sure I'm doing it right. I'm sure, I mean, unless you want to revisit it, if you've looked at it and you know what the cases are about, if you're comfortable with going forward with that, that's fine with me.
I am judge of the court is.
Okay.
I think insurance took care of the restitution issues.
Okay, so in 250300, the state's also elected to proceed on count one only. In that case, you're charged with the state jail felony offense of criminal mischief from August 29th of 2024. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I'm sorry.
Yes, ma'am.
In each of these cases, I have here on the computer, some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am, I do.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each
No
case.
objection.
It's admitted in each case. Is there any evidence that Mr. Martin is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of those pleas. In cause number 250299, find sufficient evidence to find you guilty, and at this time, find you guilty of harassment of a public servant. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 250300, also find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes.
Yes, ma'am.
Good luck to you, sir. You can go back with the bailiff. Okay, you want to talk to Mr. Westbrook real quick? I think that's all we got left.